Good morning, everybody. Wednesdays are the new Mondays here at TCF Live. I had a pre-show set up for our channel members, but failed to actually make it public, and I wondered why nobody was showing up. Oh, well, we're going to start off our day a little early then. We'll just start the big show off with Judge Middleton. Let's see if he's having a better day than I am.
I would have to believe that we have Vivian or somebody here this morning. We have a lot of cases. I believe we're going to need interpreter services. So let's see. Is Gauda Villafuerte Ferrer here? Do you need an interpreter?
Yeah.
All right, just wait a minute. Jesus Navarez, do you need an interpreter?
Yes.
Brian Castaño Trejo, need an interpreter? So far, everybody needs an interpreter who's here, which I suspected they might, so we're going to need an interpreter to join us. But let's see who we got who doesn't need an interpreter, and that would be Mr. Ryan Featherstone. Would you come up to the podium, please? I would have thought we would have for sure had an interpreter this morning, but we don't. Good morning, Mr. Featherstone.
Good morning.
This is a bench warrant arraignment. It's a little convoluted, but this is file number 251076. People versus Ryan James Featherstone. Mr. Featherstone, you were charged with trespassing in April of 2025. They filed the complaint in June of 2025, and you got arrested in June 24th of 25. You posted a $100 bond. I think you spent one day there. Then you didn't show up for your attorney pretrial and you got arrested again on December 9th, and you posted a $250 bond.
Yeah, I already done served 6 months for both these charges.
Well,
I was in jail for 6 months for that. You told me you told me you would run them both concurrent.
I did, but this was another charge.
No, that's the same one. It's the same two. I only got 2 tickets, and you said you were gonna run them concurrent. That's why I'm like shocked that I even had to get post $250 just to come here.
You had a pretrial on July 3rd. You didn't show up. Let's look at another case. This one occurred in April. Didn't get charged until June. And I think what happened is we took care of everything that there was in April. You were gone, and then in June they authorized this charge. So I think that's what happened. We didn't even know about it when I saw you.
Yeah, we did. Yeah, I told you that I had two charges and you said you run both concurrent, both tickets.
All right, well, let's take a look.
That's why I sat 6 months instead of,
6 months where?
here.
On
6
what
months
charge?
On the trespassing ticket.
You can't do 6 months on
I
a
did.
trespass.
I know. For both tickets, you ran both tickets and me fighting with the police or whatever.
Well, there was an R and O
Yeah,
charge.
the R&O and the two
All
trespassing
right, well,
ticket.
let's look at this one. All right, you had a trespass from January of 24. Judge Pattison did that one,
Mhm.
and he did that one concurrently. Then in 1076, you had another trespass in April of 25. Let's look at my notes. That was June 6th. Defendant fails to appear. All right, that's this one, 1076. And a larceny. Let's look at your felony. Judge Pattison saw you on the R&O, 29 days, credit 29 days. The only 2025 charge you have is this one.
Mhm.
And I didn't run it concurrently with anything.
You were supposed to run both tickets that I got together when I sat 6 months for the R&O. Because I got 6 months for it, and so you wrote them off concurrent.
That preceded this. This happened and all that stuff happened in 24.
Right.
All right.
It was two tickets. That's all I got.
And they were run concurrently.
Right. And
But
why
then you
am I
got
getting-
this ticket in
I've only had
25.
two. I never got another one.
All right, well, the problem is this one never got addressed. It wasn't run concurrently with anything. You missed several court dates. And so here it is, you've done 11 days in jail on this one. And you've got more than enough money to pay your fine. So you never pled guilty. You never pled guilty to this charge. So it wasn't run concurrently because you never entered a plea. If you plead guilty today, I'm going to give you 11 days credit. I'm going to give you a $200 fine, and I'll give you the balance of your bond money back.
I don't know why you told me you were going to run it concurrent. I don't understand why there's three tickets. There's only two that was given to you.
There were two in 2024.
Right.
This was 2025.
Okay, I never got another ticket. Where did I get trespassed from?
Well, let's take a look.
Because I've been trespassed from a lot of places, you know?
Yeah, that's unfortunate.
Yeah.
All right, this ticket was in Sturgis Township,
Same place.
Joseph Yoder.
Yeah, same. It's the
Yeah.
same ticket. It's this. You're supposed to run these two concurrent. It's the two that you now. I went to jail for. That's what this is all about. And I already done served 6 months, and you're trying to double jeopardy me now into something that's just messed up. I ain't trying to do all that.
Well, the point of
I
fact,
told the last guy when I came here and talked to him in the office that it was a double jeopardy. You guys are trying to get me twice. No, because it says 2024 and 2025. It's like right there at the bus, you know, between them, because I got one then and I got another one right after.
yeah, well,
And I didn't get him on a ticket after that. And that's the one I went to jail for because of Joe, because he kept my bike and almost half my stuff.
well, we're off with a bang. It's good to get back from vacation and start off with a giant clinker, but that's how some things go. I thought I kept your bike so you could get it.
I took the cops over to his shop and asked him if I could get my bike back because I talked to him on the phone. He said, "Yeah, bring the cops over and I'll give you your bike back." And I still don't have it. And I was very polite and nice to the guy. I was not rude or nothing when I got out of jail and talked to him. This is the first thing I did was bring the cops over there so I could get my bike.
Well, I tried to get your bike. There's so much stuff in here, but this is the only 2025 ticket.
Right. It was for the trespassing behind Dunham's or whatever. It's all in one spot.
Larceny, February 24. Arnold. That was Judge Pattison. Attorney Hardin failed to appear for attorney pretrial, due bench warrant after 48 hours. Failed to appear pending bench warrant, bond 250. Outstanding warrant. They ask you if you want to come in today. I can't tell what the heck is going on, but you have a lawyer in this case. You've never entered a plea. You contend it's double jeopardy. I'm gonna show. I'm gonna get Attorney Hardin in here to help us. I'm gonna set an attorney pretrial for February 6th. At 8:30. Need to explore other cases. All right, Mr. Featherstone, as far as I can tell, you never actually entered a plea in this case. You had an attorney, Jordan Hardin, but you missed so many court dates, bench warrants, and then you issue a bench warrant, and then you get picked up, and then you.
Well, I have a good person to give me a ride back and forth.
All right, very good. We'll take a look at this on February 6th with your lawyer, Jordan Hardin, here to help us. All right, sir, I'll see you on that day, and maybe we can sort it all out. We have more time to figure it out. Good morning, Vivian.
Good morning.
And good morning to all of you. Happy Wednesday. Welcome to TCF Live, where I think I've finally figured out how to run a show. Apologies to channel members for screwing up the pre-show this morning. Rookie mistake. When you create it unlisted, and then you go and you make it members only in a different section. And I forgot to do that yesterday when I created it. And there I was sitting there this morning like, why isn't anybody showing up? And then I glance over and it says unlisted. I'm like, oh, that would explain it. So apologies, but we could start the big show early today. So there's that. Let's go over to Lenawee County, see what's going on with Anna Marie Anzalone this morning.
And then I'm going to put you in the waiting room and I'll bring you back in just a moment. All right.
All right.
Thank you. Who's your
Thank
attorney?
David Goldstein.
All right. All right. So, Mr. Amadeo, Mr. Lambert still struggling to connect. So I'm going to take Mr. King. Mr. Goldstein, are you with us?
Well, I'm not against you, if that's what you mean.
Well, I didn't know if you were in some other court that was, I
No,
know
I was
you've
just-
got
No, I was just taking a nap, Judge, it's all.
all right, I know you've got all those monitors and all the courts. All right, so this is in the matter of the people of the state of Michigan versus Dustin Michael King, file number 25-22419FH. I have David Goldstein appearing on behalf of Mr. King. Today is date and time set for a pretrial conference, and I have Alexander Bayonetto appearing on behalf of the prosecutor today. So, Mr. Goldstein, how do you wish to proceed with Mr. King?
Well, before we go any further, Your Honor, I thought there were two files up today. Am I not correct?
No, I don't have two files, but what's the
no.
other file number?
No, it's a misdemeanor, Your Honor, sorry.
Okay,
It's
so
not good.
how would you like to proceed?
Well, Your Honor, we have had some discussions regarding resolution. We have not reached a resolution as of yet. I'll leave it to the court's discretion. We can either set it for a trial because it's going to be a ways out, and we can continue to negotiate, or you can adjourn the pretrial. Either way, I have no problem either way.
Why don't we set another pretrial for February 18? Are you available? No, you're not available.
No, I'm gone the entire month of February, Your Honor.
How about March 4 at 8:30?
Hang on one second, Judge. Well, I do
March
have-
11?
hang on.
March 11?
My calendar is acting funny this morning. Hang on one second. March 11th would work better, Your Honor.
All right, so Mr. King, I'm going to set this over for a pretrial on March 11 at 8:30. And Mr. Goldstein, can you do this step in order to
Sure.
adjourn? And Mr. Bayonetto, can he sign your name with permission?
Yes, thank you.
Mr. King, we'll see you back on that day. Thank you.
Thank you.
All right, since Mr. Goldstein, your other client is Mr. Simmons.
Correct.
All right, Mr. Simmons, if you'd like to unmute your device and start your audio. All right, excellent. This is in the matter of the people of the state of Michigan versus Emmanuel Simmons. We have two files, 24-22051FH and 24-22052. FH. I have David Goldstein appearing on behalf of Mr. Simmons. Mr. Simmons is appearing via Zoom. And I have Alexander Bayonetto appearing on behalf of the people. Mr. Coast did provide an update that Mr. Simmons is doing okay with his drug testing at the center. He did miss January 6th, but he's only testing positive for marijuana and occasionally alcohol. He has presented with a valid medical marijuana card. So Mr. Simmons is doing well on his testing at this point. So that's excellent. So Mr. Goldstein, how would you like to proceed today with Mr. Simmons?
We're going to need a trial date. We're going to need trial dates, Your Honor.
All right. And Mr. Coast, was there anything you wanted to add to that?
No, ma'am, he is doing much better. He is staying away from the cocaine. So I'm pleased with what he's doing.
Okay. All right, and we have two files, and the We would start, well, the trial would be on the 24-22051FH file. So, Mr. Goldstein, how many days do you think you will need?
2.
All right, does that include deliberations or no?
No, Your Honor. You can never
Okay.
predict how long a jury is going to deliberate.
Yep. So, Ms. Adams, I'm looking for a 3-day jury trial. As we're all aware, Mr. Goldstein is going somewhere warm for the month of February. So, April, maybe.
Judge, we have March 24th through 26th.
Your Honor, this is going to be Mr. McCready's case. He is scheduled to be in trial with Judge Olsaver until I believe the last week of March. So if we could go into April.
Is that all right, Mr. Goldstein? Because we do have the murder trial going on in Judge Olsaver's
Yeah.
court for several weeks.
Yeah, at least several weeks.
At
Judge,
least, all right.
my client's not in custody, Your Honor, so I don't have a problem. The only thing is I start on March the 6th. I'm sorry, April the 6th, a jury trial in Washtenaw County that we've got scheduled for 2 weeks. I don't think it's going to go 2 weeks, but we've got it blocked. We got 2 weeks blocked out.
So, Ms. Adams, second, end of April, maybe the last week of April?
We've got, in April, we've got start date of the 14th or the 22nd, and then we're into May 26th.
April 22nd works. I'm sorry, you say 22nd?
Correct.
Yeah, that works.
All right, so
That works for the people
April
as well.
20. Okay, April 22nd is a Wednesday, so it'd start at 10:30 a.m. And let's see, I will set a final pretrial for April 15. Would that day work, Ms. Adams?
I'm sorry, Judge, what?
April 8th. I'm gonna set a final pretrial for April 8th. And that would be at 8:30 a.m. I would ask that voir dire questions and jury instructions be provided to the court by April 3rd. And I will make April 8th the motion deadline. Is there anything else, Mr. Goldstein or Mr. Banetto?
Not on these matters,
No,
Your
Your
Honor, but I forgot to write down the date for Dustin King. I'm sorry, Your Honor.
Dustin King was, let me get back there.
March
11 at 8:30.
11th. Thank you.
Okay, I filled out a scheduling order. We will get a copy of this out to everybody. And we will see you back then. Thank you all. Your bond's continued.
Thank you.
Thank you.
Thank you. And Mr. Goldstein is all set. So Mr. Amadeo, Mr. Lambert has been able to connect. So, the matter of the people of the state of Michigan versus Randall Allen Lambert, file number 26-22513FH, and William Amadeo appearing on behalf of Mr. Lambert, and Phoebe McClure appearing on behalf of the people. Ms. McClure, is this your assigned file?
It is, Your Honor.
All right, so this is a date and time set for pretrial. Mr. Amadeo, is it pretrial or arraignment? It's set for arraignment. So Mr. Amadeo, do you waive the reading of the felony information?
Waive a formal reading, stand mute, Your Honor, and just ask for another pre-trial date. We actually have this case resolved, Judge. It's just that Mr. Lambert didn't have internet access, and I've been in a murder trial, but I plan to meet him to get some paperwork signed in the next couple weeks. I'll come to Lenawee to meet with him, but this won't be going to trial, Judge. We basically resolved this in district court. We just have to do it before you.
So I'm going to set this over as February 11 at 8:30. Okay, Mr. Amadeo.
That works great. Thank you, Judge.
All right, and Mr. Amadeo, if you can prepare the stip in order to adjourn. Ms. McClure, can you sign your name with permission?
Yes, Your Honor.
All right, Mr. Lambert, we'll see. What? Somebody
It's an
say
arraignment. I can go ahead and do the notice.
Oh, I'm sorry, we do the notice. So I'll enter a plea of not guilty. We'll set this for pretrial February 11 at 8:30. So Mr. Amadeo, we do the notice. Sorry about that.
No problem. Thank you, Judge.
All right, thank you, Mr. Lambert. You're all set.
Okay.
Okay, so Mr. Murphy,
Thank you.
Good morning, Your Honor.
good morning. Not seeing any attorney here. Okay, Mr. Murphy, you waived Caldwell. Michael Guzman in the courtroom. You want to come up to the podium? All right, Mr. Murphy, this is in the matter of Michael Fidel Guzman, file number 25-22478FH, and Matt Murphy appearing on behalf of Mr. Guzman. And I have Alexander Banetto appearing on behalf of the people. Are you my prosecutor today, Mr. Banetto?
I am, Judge.
Okay, so this is date and time set for pretrial. Mr. Murphy, how would you like to proceed?
Yes, Your Honor, thank you. I am covering for Mr. Malaro. His notes on this file was to just ask for another pretrial in this matter, to ask to adjourn if there's no objection by the prosecutor. So that's what I'm asking for, just set another pretrial, whatever fits the court schedule best.
All right, Ms. Adams, I'll need a notice of hearing for February 11 at 8:30. So Mr. Guzman, I'm going to set this over for February 11 at 8:30 in the morning. And because you're here in person, we'll do the notice. So I have a seat on the bench behind you and we'll get you that notice of hearing. All right. You're
Thank you, Your Honor.
All right, Mr. Murphy, you have somebody in jail, so let me call them.
And I'm also covering, I believe there's a Cody Allen extradition.
Hi, this is Judge Anzalone. I am ready for Malachi. Yeah, it was a typo. Malachi Welke, and you said Taylor, Mr. Murphy?
Cody Allen, I think there's a extradition.
And then I'm ready on Cody Allen as well.
Cody Allen and Malachi Welke.
Yes, thank you.
Yep, bye-bye.
Bye-bye.
All right.
Miss Adams, was it Cody that had all the new cases? Cody Taylor?
Yes, hearing on January 30th.
So Mr. Murphy, on that extradition, Mr. Taylor has a ton of new
Yes.
felonies and the next, oh, wait, yes, Miss Adams?
Cody Allen, sorry.
Okay, Cody Allen has a bunch of new felonies, so I'm gonna adjourn this out past the next district court date. All right, which is January 30th.
We just waived his exam downstairs yesterday, on his files. So that's one of the, when I was confused why there's an extradition. So
Well, they're two different things, right? So when's his arraignment up here?
that would have been set for, would that be the 28th, I believe?
I believe it is next Wednesday.
All right, so we can set this over to next Wednesday too, which would be January 28th. Mr. Dagger Margosian, I have Stephen Markowiak.
Morning, Your Honor. We're ready on that.
Okay. Mr.
Hello?
Markowiak, you want to start your video, please?
Yeah, let me put a hat on. Sorry, I just woke up. 2 seconds.
All right, are you Cody Allen?
I am, yes.
Okay, in the matter of the people of the state of Michigan versus Cody Isaac Allen, file number 26-22515AX, and Matthew Murphy appearing on behalf of Mr. Allen. So, Mr. Allen, today is a date and time scheduled for an extradition hearing, but Mr. Murphy did inform the court that you had waived your preliminary exam in district court, and you are scheduled to appear up here again on January 28th. So I'm going to adjourn this extradition hearing over to January 28th at the same time. Okay, Mr. Allen?
Yes, ma'am.
All right, so you're all set, sir. Thank you.
Thank you
Mr.
so
Chairman,
much.
I'll talk to you soon, okay? If not this afternoon, tomorrow, all right?
All right, thank you.
All right, Mr. Dagger Markosian in the matter of the people of the state of Michigan versus Stephen Matthew Rakowiak, file number 25-22431FH. This is a date and time set for pretrial of Michael Dagger Markosian appearing on behalf of Mr. Rakowiak. And I have Phoebe McClure appearing on behalf of the people. This is date and time set for pretrial. Mr. Dagger Markosian, how would you like to proceed?
Your Honor, Mr. Rakowiak is currently doing the ECU deferred program. I'm not sure that he's made a payment yet. I spoke with him yesterday about his financials, and basically what he told me is that he was having an issue with his landlord as far as paying rent. He has worked an agreement out with the landlord so that he now has like a stable housing situation and can now start to make payments on this restitution issue. Obviously, he understands the importance of the restitution being paid, as that will result in a dismissal, and that's what obviously he's gunning for. So I would ask the court and the prosecutor to just maybe show a little grace here and just give him a little more time. There's no intention of him not paying it, but he just needs a little more time here.
So, Ms. McClure, any objection to adjourning this to February 18 to see if he's made progress?
No, Your Honor. And for the record, he did make 2 payments in November, and then we had a pre-trial at the end of November, and he's not made a payment since then, but he did make those 2 initial payments. So we would just ask that as long as he makes a payment by the next pre-trial, then we know he's making progress.
All right, so Mr. Rakowiak, I'm going to adjourn this to February 18th at 8:30 in the morning. And Mr. Dagger Markosian, if you can do the step in order to adjourn, and Ms. McClure, can you sign your name with permission?
Yeah.
All right, thank
Will do, Your
you.
Honor. Thank you.
Jail revolt.
Hey, this is Judge Ann Sloan again. I am actually ready for Timothy Neves.
Leave.
Yeah, that'll work.
All right, ma'am, I'll get it for you.
All right, thank you. Bye. All right, so I have in the jail, are you Malachi Welke?
Yes, Your Honor.
Okay, so in the matter of the people of the state of Michigan versus Malachi Welke, we have 2 files, 25-22491FH, 25-22498FH. Mr. Murphy, is this your file or are you covering this file?
Oh, yeah, this is my file.
Hold on.
Your Honor, in
hold on.
regards to Ms.
Hold on. So I have Matthew Murphy appearing on behalf of Mr. Welke, and I have Alexander Bandetto appearing on behalf of the people. I do have a letter dated January 20 of 26 from Darren Coast, my pretrial services coordinator. He states that Emily White from the Public Defender's Office called to say that Mr. Welke has been approved to go to treatment at Ohio Guidestone in Napoleon, Ohio on January 22nd. His mother planned on doing the transport from the jail to the treatment facility. Ms. White stated that Judge Shadler approved for him to go, but there are no notes in our files allowing him to go. Mr. Close would be happy to do monitoring of his progress. So we need to address that today in circuit court. Now you can talk, Mr. Murphy.
Yes, Your Honor. There's been some issues. We're just wanting to make sure with Mr. Welke's file, then obviously with other files moving forward, that we get this issue cured. I think we've got to figure it out. But obviously, Mr. Welke wanted to. He requested, and we processed him. We had Ms. White screen him and had him go into trying to get him into a rehab facility. I believe the people's offer was predicated upon him successfully completing that, entering and completing that. So we're just asking for an adjournment of this pretrial. And again, just clarification that Your Honor is okay with him. Because again, it was ordered down in district court. And I'm not sure if those orders are continuing along on the circuit court files. So we just want, Your Honor, again, obviously it's up to Your Honor whether or not he's allowed to, on your bond, continuing to go to the rehab or not. So I do believe that it's appropriate for him to go into the rehab at this time. He's a young man and he understands the situation in his life to address these issues. And obviously, like I said, I believe that the people are hoping he'll do it as well. And I don't believe if he intends to abscond or anything from there, he does intend to complete it successfully. Again, use the tools that he's going to gain from there for the rest of his life. So we'd ask the court again to allow him to be released to that inpatient facility. And again, just set this for another pretrial, whatever fits the court's schedule best.
Mr. Bayonetto, any position?
Your Honor, I do see in our notes that he was ordered to be released to rehab when that was available by Judge Shadler on December 22nd of 2025. So I don't have any objection at this point if he is released.
Great, excellent. So I signed the order allowing him to be released tomorrow morning at 9 a.m. Mr. Welke, it's very important that when you get there, you tell them that Mr. Coast, you sign a waiver allowing Mr. Coast to be able to verify that you remain there and you successfully completed, all right?
Okay.
All right, and Mr. Coast, do you need to talk to him or are we good?
Judge, can I have a quick breakout with him, please?
Yeah. So I'm going to open up a breakout room, Mr. Welke, and you go ahead and click on join that breakout room and he will give you some information.
Are we doing a
And
new date, Judge?
Becky, what?
Are we doing a new date? I'm sorry. I was just trying.
Yeah, we are. How long is this program? Is it a 90-day? Do we know?
Mr. Welke, do you know how long it is? I thought it was 90, but maybe I'm mistaken.
Yeah, my mother said it's a 90-day program.
So Miss Adams, could I get a date like the last week of April? Do we have a date?
April 20.
April 22nd or April 29?
Yeah, 2/9.
All right, so we're gonna set this over to April 29 at 8:30 in the morning. Mr. Murphy, you can do the stip in order to adjourn. Mr.
Yes,
Welke, upon your release, Mr. Post is gonna give you some instructions, but you'll have to appear that day either via Zoom, in person, or from Mr. Murphy's office. Facilities will allow you to appear via Zoom as well. So
Okay.
in case you're still there, so go ahead and join that breakout room and then you're all set, okay?
Okay, thank you, Your Honor.
Thank you. Okay,
Well, she racks up the next contestant. Good morning once again, everybody. TCF Live on a Wednesday. Good to have you all here. A lot of courts still coming online. Best place to stay at the moment is Judge Anzalone. She's got the most going on, so we'll ride here for a little while.
Mr. Neves, all right, let me grab your file. This is in the matter of the people of the state of Michigan versus Timothy Jerome Neves, file number 25-22222 FC. I have Michael Dagger Margosian appearing on behalf of Mr. Neves, and I have Alexander Bayonetto appearing on behalf of the people. This is the date and time set for a final pretrial in this matter. So we must have a jury trial date scheduled for February 4 of 26. I do show that the people have filed on January 7 a notice of intent to use other acts evidence. So Mr. Dagger Margosian, are you ready to proceed to trial?
We are. Just a few items, Your Honor. It's actually set for a bench trial on the
Right.
on
I'm sorry,
February 4th.
I thought I said that.
And we've received the notice. My response is ready to be submitted, but I wanted to wait until today's pretrial to get some guidance on how the court wants it to be scheduled. If we wanted to, and I talked with Mr. Bayonetto yesterday about this, and I think both him and I think that it should be set for the hearing for the 404B admission, or keeping it out should be scheduled for probably a date before the trial. Obviously, it's up to the court if you wanted to do it day of or before. But I think it would probably make sense to have a hearing on the inadmissibility or admissibility of it, maybe about a week before the trial. But other than that, we're set to go for trial.
Ms. Adams, do I have anything the week of January 26th for an hour?
You actually do on January 27th. Could do a 10, 11, or the afternoon.
January 27 at 10 a.m.
Could do 11.
January 27 at 11 a.m. Mr. Dagger Margosian?
Yeah, that works. Judge, what I'll do is
All
I'll
right.
file it.
Yep, file your response with the date, notice of
Will do.
hearing. All right, Mr. Neves, well, do you want that in person or via Zoom? Do you want your client here in person or via Zoom?
I'd like to be in person as well as my client, Your Honor.
All right, so make sure you put that in the notice of hearing, all right?
Will do. Thank you, Your Honor.
All right, we'll see you back on that day. Thank you, Mr. Neves.
Thank you. Have a good day.
You too. Okay. Nathan Steers. Mr. Steers, you want to come up to the podium? All right, this is in the matter of the people of the state of Michigan versus Nathan Dwayne Steers, file number 25-22429FH. I have Michael Dagger Margosian appearing on behalf of Mr. Steers, and I have Alexander Bayonetto appearing on behalf of the people. This is the date and time set for a pretrial conference. So, Mr. Dagger Margosian, how would you like to proceed?
Your Honor, may I speak with Mr. Steers on Zoom, please?
You know how to use the Zoom in the hallway? All right, so my bailiff's gonna take you out because he's also IT. So he's gonna take you out and connect you to the Zoom device in the hallway. All right,
Not to interrupt, but real quick, I just got to point out, she just said bailiff/IT. I hope you caught that. Small counties, combo products when it comes to your job, I guess.
all right, Miss Underwood, Sky Shun Tyndall. Just let me call that one. Is Sky Shun Tyndall in the hall? I didn't, he usually comes in. All right, Mr. Dagger Margosian, I'm gonna open up a breakout room with the circuit court hallway and yourself. You probably got to show him how to unmute and start his video.
No, he's not.
No. All right, and then as soon as you get out there, I'll set a invitation.
All right, let's change it up a little bit. Let's rotate back to Judge Middleton. It looks like he's moved past his translator cases, which take like 27 hours with him. So let's go back there.
Great.
Correct, Your Honor.
We get lots of these. The file number here is 252717SM. Fane Martin. Takes me a minute to shift gears from translator mode to non-translator mode.
Not a problem. Take your time, Your Honor.
It's humbling to be somewhere where you don't speak the language. And for all of our Mexican and Central American people, they're here and they're trying to figure out what's going on. They don't speak the language. Although if they're here for 6 years, they ought to be able to speak the language. But I was just in Panama and I don't speak Spanish. Everybody talks very quickly and I didn't understand much of what was going on. But they're much more tolerant than many Central American people speak English. So it is humbling to go somewhere where you don't speak the language. And I try to keep that in mind when dealing with our people that don't speak English. But if I went to Panama for 6 years, I think I learned to speak Spanish. Anyway, you got a charge of no insurance and no registration. Those are very common. No insurance is a misdemeanor. It's punishable by up to a year in jail and a fine of up to $500, not less than $200. The no registration is a civil infraction, the way they charge this, and it carries a $105 fine. So let me ask you this. Do you have proof of insurance and registration with you now?
I have the proof of insurance, but the registration, I was trying to get the title transferred over and everything, and I need a, believe it's a lien release paper from the previous owner that I bought the vehicle from. And I have contacted that owner and he is
All
working
right, so
on
you're
getting it.
working on getting a proper registration?
Yes, Your Honor.
And that's an Indiana registration
Uh,
or Michigan?
I believe with the title, it is Michigan.
All right.
I believe it's- Yeah, state of Michigan.
All right, well, one option, we can adjourn this a couple weeks and let you get that straightened out and come back with both insurance and registration. In which case, I think the prosecution would give you some consideration. They'll often reduce the no insurance to something less. We can try to do a pretrial with the prosecutor right now, but my guess is they're going to ask you to come back with that proof of registration. Are you willing to do that?
Yeah.
I'm sorry, that means coming back on another cold day, but
But life is life, you know?
yeah. Needs to transfer title.
And would you like to see the proof of insurance now? Or does it matter too much?
No, just hold on to it.
Okay.
Well, is it in paper form?
I have it on my phone.
No, hold on to it. If we had a paper one, I'd copy it, but
Oh, understandable. Yeah, by the time I come back, I should have the paper form.
all right, how much time do you need for that?
It's kind of hard to say because I'm just waiting on.
Well, how about if we do a month?
I would like to assume that that would be plenty of time.
All right, set for pretrial for February 11. That's not quite a month. February 25th. 8:30. That was a long wait for that, but we do the interpreter cases first because often the interpreters are in demand in other places. And I try not to make them wait, but it makes everybody else wait. But I'm going to give you a notice in my poor handwriting.
My handwriting isn't the best either.
If I had a clerk in here, I'd have them do it. I'm going to try to do that before the next judge takes over. Set up a clerk in here. That would be Wednesday, February 25th. 2026 at 8:30. Bring proof of registration. Wait a minute. I think I'm going on that day. No, I'm here. All right, I'll see you in about a month. You'll bring proof of insurance and registration, and we'll have you meet with the prosecutor and see what they can do. Mr. Martin, thank you for your patience.
Thank you, Your Honor.
He needs to get printed on this insurance case. I'll go ahead and do it. The insurance is punishable by up to a year in jail. It requires that your fingerprints get taken, and we'll take care of that here this morning. You go to the court officer, and then I'll see you in a month.
Okay, thank you, Your Honor.
252706. This is an ordinance case. This is Xavier Marcus Ringler.
Well, he racks up the next contestant. Good morning once again, everybody. Tanya, thanks for joining us, and thanks for playing bingo, something that you'll never find on any other court channel, I will declare. But Ellie, you asked about. Ellie is our kitten. I'm going to try to bribe her over here right now because I'm opening up a yogurt for breakfast, and Ellie loves yogurt. So keep your eye on camera, and we might get you an extra bingo square.
I've been gone for 6 business days. Let's see if I remember how to do all this. You got a ticket for no license ever applied and speeding, just like all the other folks here this morning. Yours was December 29th of 2025 in Ottawa and Hatch. They alleged that you were going $40 and a $30. They must write a lot of tickets right there.
Yes, sir, they do.
All right. Now, your problem is you got $538 worth of unpaid fines. No insurance, no proof of insurance. There's a 25 left over. Registration plate, defective equipment, and a previous charge of failed to display a valid license. Let's take a look at those. I don't think they're all the same date.
Yeah, no, I don't believe so, sir. I don't know where the registration or improper equipment would be from.
They look to me like maybe they got defaulted. So let's take a look at this. You got a ticket for no proof of insurance on January 8th of 2025.
I remember that one.
And they reduced it to no proof of insurance. You'll find in that one. Let's look at this one. For May 31st, 2025, defective equipment. And you didn't respond to the ticket. That was a fix-it ticket. And
does it by chance specify what like the equipment might have been?
well, I can tell you if I can find the ticket, but it's probably not in here. E-file belongs with criminal case. No ops ever applied. Well, that's this ticket. For October 25, failed to display a valid license. E-ticket, fine and costs, misdemeanor letter, default. So you got defaulted on the October ticket. So you apparently didn't get the memo. No proof of insurance on January 25th. Registration plate violation on May 21st. Driving without a valid license in this case, December of 25.
Yep.
And then driving without a valid license in October of 25. So some of those, one, the insurance you pled guilty to. The other ones, you didn't show up and you got defaulted.
I was told with the previous ticket for driving without ever having received a Michigan, I showed up for the hearing for that one and they told me not that I wasn't supposed to be here. because of the way that the officer wrote the ticket.
Well, it should be a misdemeanor, not a civil infraction.
Yeah, I wasn't sure. That was a whole mess
Well,
that day.
it looks like there's some credibility to that. What are you doing now? Are you trying to get your license?
So I actually thought I had my license because I had paid my fines, because my license is in Indiana, it's suspended on, I think, improper equipment from a vehicle that I owned in late 2024. And I had gotten a ticket for that I had just spaced on paying. So they suspended my license. I got pulled over in October up here in Sturgis, and the officer informed me my license was suspended. So I contacted the Indiana BMV trying to figure out like why it was suspended. That was when they informed me that the unpaid ticket was what suspended it. I had to pay that ticket and a reinstatement fee to the BMV. And I paid
So did you do that?
Yeah, I paid the reinstatement fee, and then they said they had to send an SR-16 to LaGrange County in Indiana and wait for a response from them. And that's the furthest I've gotten with that. And then I got pulled over in December here, door dashing.
If I sit there and get all the door dashers going 40 and a 30. Anyway, you could use some help here. I think I'm gonna appoint an attorney. Your livelihood depends on your driver's license. Now,
I got a ride. I was in Kalamazoo overnight with my fiance. She's doing chemotherapy up there. So after her appointment, we came down here.
All right.
I got to get a ride out of here though.
Do you need a bus pass to get back to Sturgis?
No, I'm waiting on my mom, actually. I'm sure she's probably here by now.
All right, set attorney pretrial for February 6th. 2026 at 8:30. You need to gather all your documentation from Indiana here, these unpaid tickets. You ignored the tickets, so they got defaulted.
So with that, I've been in the process, like long-term, of moving from Wookettville, Indiana, which I don't know if that's my current address on file or not.
It is. Do you have a local address?
It'd be 703.
Well, don't put it here on the live stream, but when you go out to see the clerks, get your current address.
All right. Yeah, because I'm in the process of moving up to Sturgis.
All right, get current address. Yeah, once you get on the driving suspended merry-go-round, it's very hard to get off of it.
Yes, sir.
And so let's see if we can get you off of it. Here it is. All right, you go with the court officer and we'll get a lawyer, and you need to align your waterfowl, and I will see you on February the 6th. We'll try to sort this out.
Thank you, Your Honor.
So 2 new bingo squares that I just thought of: align your waterfowl, because he says that a lot, and a defendant saying, I'm in the process of ... Everybody's in the process of something, but that would almost be a free square, wouldn't it? Because we pretty much see that every day. Anywho, let's change it up. Let's go down to Florida. Wade Mercer.
Mr. Dennis, you've got a family member in the courtroom. You're here because you've been accused of two similar charges. One count is sexual battery by oral genital contact with a victim under 18. One count of sexual battery by digital penetration contact with a victim under 18. So it's 2 first-degree felonies punishable by life. What that means is, if you're convicted, and you've just accused, you haven't been convicted of anything, but if you're convicted, the maximum penalties for both of these charges is life in prison. That's where we stand. There is probable cause in the complaint. I'm going to appoint the public defender's office to represent you for first appearance purposes, and we're going to listen to the attorneys, and I'm going to address your bond status. Mr. Mitchell, anything from the state?
We just request a high bond, given the serious nature of these charges, and that he have no contact with any minors whatsoever.
So we'll come back to that in just a second. Let me deal with the bond first. Mr. McDaniel?
Your Honor, we just, we'd asked for a reasonable bond and, I mean, these are, I think the allegations are they're older, but I would have no problem with, I don't think anyone's gonna have a problem with no contact with, minor kids, you know what I mean? But I mean, these were older, but, and I don't think, I'm not positive, but reading through the complaint, I'm not sure if this is the first time that this has been alleged, you know what I mean? Which kind of brings in the question marks in my mind. I mean, I've seen something happen in Texas and, I mean, I didn't ask, and I'm not going to ask him specifically. I just read through the complaint. It kind of seemed kind of weird that we're talking about some of the stuff that happened in Texas.
It wasn't real clear if there was some kind of abuse, like a physical abuse alleged, or if there's a sexual abuse alleged, but it wasn't real clear. Something had been alleged previously, but I got the impression it wasn't sexual abuse. That's at least my impression. My concern about the no contact with minors is doesn't he have one minor child that said that nothing like this has ever happened to her? So I'm considering no unsupervised contact with minors as opposed to no contact. Mr. Mitchell?
Yeah,
I don't want to
say would be fine with that.
Okay. Mr. Dennis, these are very serious charges, sir. Again, you're just accused of these crimes. There's evidence of multiple alleged victims, but you're not accused of those because those allegedly occurred in other jurisdictions, not in Florida. Only one of these children says this happened in the state of Florida or in Jackson County. That's what you're dealing with here today, those accusations. Your bond's going to be $50,000 in each count for these two Florida charges. That's a total of $100,000 cash or surety. You have a condition of no contact at all with the alleged victim in this case, and no contact with any minors without supervision of an adult who's responsible for that child's care and is aware of the allegations. Mr. Dennis, you need to understand, like I told you yesterday, there's allegations of other offenses that occurred outside of Florida. As far as I know, you have not been charged with those. But just like I told you yesterday, when you had just a misdemeanor, it's certainly possible, maybe even likely, that there'll be other charges coming in other jurisdictions. If that happens, they will have separate bonds on those. So what I'm dealing with today is the bonds on the two charges you have in Jackson County. That bond's $100,000 cash or surety with the conditions that I've already put on the record. You will get to use the phone in a few minutes, sir, to try to post the bond. If you post the bond, you'll be released under those conditions. If you don't post the bond, the public defender's office will be in contact with you at the jail. The other thing that I'm going to do is ask the jail to give you a notice for your court date, which would be February the 3rd at 8:30. That'll be your arraignment date, or your either your arraignment or your pre-arraignment, depending on whether the state has filed charges or not at that point, and that'll be in front of Judge Garcia. Mr. Dennis, do you have any questions?
No, sir.
Wish you the best, sir.
Don, is that cut off tomorrow? Okay.
We have Odalie Myrick. Mr. Myrick, good morning. Mr. Myrick, you're here for first appearance. You're accused of 3 new charges. Sir, you're accused of 1 count of trafficking in methamphetamine, 1 count of possession with intent to distribute, and 1 count of resisting an officer without violence. There is probable cause for the 3 charges. Mr. Myrick, it appears you're on probation in Jackson County for 2 different felony case numbers. So I'm going to listen to the attorneys and I'm going to address your bond situation. Mr. Mitchell, anything from the state?
Your Honor, on the probation cases, we request a 7-day hold so we can see if probation is going to put a warrant out for those 2 cases. As for the new law charges, we request that he be subject to random UAs.
Thank you, Mr. McDaniel.
Nothing, Your Honor.
So, Mr. Myrick, I set a higher bond for individuals who are on probation and they're accused of crimes the vast majority of the time than individuals who are not on probation. For that reason, your bond in the trafficking case is going to be $75,000. Your bond in the possession with intent to distribute will be $25,000. Your bond in the resisting without violence will be $5,000. So your total bond in today's new charges is $105,000. But as Mr. Mitchell requested, when someone's on probation, we typically hold the individual 7 days if there's probable cause for a new crime, especially a felony. And that gives the probation office time to decide whether they're going to seek a warrant or not and obtain a warrant from the supervising judge, which is probably going to be Judge Garcia in your case. So, Mr. Myrick, you have no bond for 7 days. We'll see if they get a warrant or not. But your bond on the cases I am setting a bond is $105. Mr. Mitchell, I've got case numbers 24-32CF and 20-672 as the ones he's on supervision for.
That's what
So,
I had.
Mr. Myrick, you do get to use the phone to contact friends or family and tell them what's going on, even though you're not entitled to a bond in the possible VOP. I'll see you in 7 days. If they don't have a warrant in that VOP case, I'll release that hold, and you'll be free to post bond in the new cases if you can, if you wish. And if you are on bond at some point, you do have a condition of random urinalysis in the new cases. Mr. Myrick, I'll see you in 7 days. Do you have any questions?
I don't.
Have a good day, sir. Do need to give him a court date for February the 3rd.
Real quick, Barbara, thank you for that gifted membership earlier. I forgot to thank you for that. Very much appreciated.
Thank you. And last case we have is Sabrina Lindsay, or last case on first appearance list, at least. Miss Lindsay, come on up. Miss Lindsay, good morning, ma'am. You have a holdout of Wakulla County. The information we received from their sheriff's department, ma'am, says you're accused of violation of probation there, and the warrant has no bond on it. So, Miss Lindsay, you'll be held for Wakulla County. They'll be notified. They probably have already been notified. If not, the jail notify them this morning after first appearance that you can be picked up. Miss Lindsay, they'll pick you up. When you get picked up, you'll go to Wakulla County. You'll go to another first appearance there, and that local judge will address your bond status. It may or may not change. It certainly may stay the same. I don't know, but right now you have no bond. If you're here in 15 days, you come back to first appearance and we'll see what's going on with the transport. That is very unlikely because Wakulla County is so close to us. In all likelihood, you're going to be back over in Wakulla County within the next 2 or 3 working days. Do you have any questions,
Yes, sir.
ma'am?
No,
Have a good day, ma'am.
thank you.
Yes, ma'am. And are any of these? They're all out. Okay, so Corporal, that's everything I had on my first appearance list.
Quick work of that for Judge Mercer this morning. Let's go back up to Michigan. Judge Simpson's getting his day going.
To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of People versus Stephen Schoppel.
Morning, Honor. Bring the people.
Grandma TCF gifting 5 memberships. Thank you so much, Mom. Appreciate that.
On behalf of Mr. Schoppel, state your name. Ralph Stephen Schoppel.
Thank you. Set for arraignment.
Waive formal reading of the complaint, Your Honor. Stand mute to the charge.
And in every waive formal reading, standing mute, the court will enter a not guilty plea.
Your Honor, with respect to the pretrial conference, Mr. Cook and I have been talking. There's a, I'll call it a native video that is referenced in the police report, and you can kind of see it on the body worn camera that we are trying to obtain. Mr. Cook has made a couple of efforts, but doesn't have that answer yet. And so we're asking to adjourn the pretrial conference.
Pretrial conference in this matter will be adjourned to.
February 4th.
Does that be enough time, you think?
I hope so, Your Honor.
February 4th, 2026, 9 a.m. The bond in this case set his bond at a $10,000 personal recognizance bond. Standard conditions, including no assault behavior or possession of any weapons or firearms or anything fashioned to be a weapon. No alcohol, recreational marijuana, or any illegal drugs. Is there any reason?
No.
You can, any reason to have contact?
No, You're on a total straight.
I will order no contact with that individual.
Your Honor, with people request also no contact with Swan Po Liu. I'm going to butcher that pronunciation. That's the victim's partner that was also at the incident. I can spell that.
Yes, well, you'll have to.
HSUAN.
HSUAN.
-PO.
Okay.
And then last name is Liu, Liu.
That is not at all what you said, but that's.
I tried.
No. All right. All right. And I don't know, do we need well, that's actually Costco's, so not going to worry about it. Okay.
Thank you, Your Honor.
Thank you.
Wait for me outside.
Calls case People versus Sharon Abbott.
People.
Sherilyn Foster Tucker on behalf of Sharon Abbott. Your Honor, Miss Abbott is not here today. She did call me this morning, and she is headed to the emergency room for a medical emergency. She said she'd provide me documentation when she can get that. I was going to ask for an adjournment for continuing to work towards a resolution. So that would still be my request today.
Right, we have to find a way to get this resolved, as it's been adjourned a number of times.
Okay.
What date was that?
February 4th.
I'll give one last adjournment, February 4th, 2026, 9 a.m.
Thank you, Your Honor.
Court calls case People versus Tatiana Tedder.
Morning, Your Honor, Raymond Cook with People.
Sherilyn Foster Tucker on behalf of Tatiana Tedder, who should be on the Zoom.
Yes, I'm on here.
Okay, I'll need a camera.
Okay.
Actually has it on, it's covered. Oh, there you are. Okay.
Thank you, Your Honor. I'm asking for an adjournment in this case. I just need to get some information to the prosecutor and we're working towards a resolution.
February 4th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case People versus Kiana Patterson.
Morning, Your Honor, Raymond Cook with People.
Public Defender Natalie Pate on behalf of Ms. Patterson, who should be present, or hopefully present on Zoom. Your Honor, I do not have an explanation here. I did provide her with the Zoom information as well as leave her a voicemail, but unfortunately did not hear back. For the record, I request an adjournment.
Bench warrant will issue for defendant's failure to appear. I would note that this is now her 4th bench warrant. Bond is set in the amount of 10,000. We have a 10% privilege still on that, but that warrant will issue immediately.
Thank you, Your Honor.
Going to indicate don't set aside. She'll have to appear. Court calls case People versus Wally S. Salisbury. What, Wally S. Salisbury? Not here, I'll issue an order to show cause. Carlton Cross.
Ron Brown, appearing on behalf of Carlton Cross, Your Honor. I talked to him yesterday.
Raymond Cook with People.
Yeah, it says Carlton right there, Cross right there.
Well, that's not Cross, but I think,
I needed my prescription check.
yeah, I think so.
I'm here. Hello?
Okay, what's your name?
Carlton
What's your name,
Dion
sir?
Cross. I'm sorry, sir. Carlton Dion Cross.
All right.
Your Honor, Ron Brown, appearing on behalf of Mr. Cross. I talked to him the other day. I'm requesting an adjournment for him.
Adjourn the matter to February 4th, 2026, 9 a.m. Bond continued. Thank you, sir.
All right, thank you,
Make
sir.
sure
Have
you
a
get
good
the
day.
Judge Kunkies. Make sure you get the good Judge Kunkies and you call me.
Court calls case People versus Grant DeCia.
Morning, Your Honor, Raymond Cook with People.
Ron Brown, appearing on behalf of Grant DeCia.
Your name?
Grant Matthew Duche.
Shay.
Your Honor, I'm requesting an adjournment. Can we get the same date that you just gave us?
That's the only date I'm giving you. February 4th, 2026, 9 a.m. Bond continued.
All right, you got homework now. So we'll see you.
Court
on the
calls
4th.
case
And I'll
People
call you
versus
before.
James Hagan.
Morning, Your Honor, Raymond Cook with People.
Assistant Public Defender Natalie Pate with it on behalf of Mr. Hagan, who should be on the Zoom. Sir, can you please let me state your name for the court?
James Hagan.
I need a camera, sir, please. There he is. All right, thank you.
Thank you, Your Honor. Thank you. I have been able to discuss this matter further with my client, and we do believe discovery is complete. At this time, my client's asking to set it for final settlement conference.
Jury final settlement conference, February 6th, 2026, 9 a.m. Jury selection if necessary, February 9th, 2026, 8:30. Both of those proceedings are in person. Bond will continue. Thank you.
Thank you, Your Honor. Thank you, Mr. Hagan.
Court calls case of the People versus Maya Hines.
Ron Brown appearing on behalf of Maya Hines, Your Honor.
State your name, ma'am.
Maya Hines.
What are we doing?
Your Honor, did you receive a plea form in this case?
Advice of right. I don't have anything.
Your Honor, may we adjourn the case? February 4th.
Adjourn the matter February 4th, 2026, 9 a.m.
We'll see you on the
Thank
4th, Ms. Hines.
Okay, thank you.
Calls case People versus Alicia Colowick.
Here. Assistant Public Defender Natalie Pate with and on behalf of Ms. Calloway, who is there on Zoom. May I state your full name for the court?
Alicia Calloway.
Thank you.
Your Honor, may Mr. Cook and I very briefly approach? Thank you.
Very brief approaches in Judge Simpson's court tend to not always be very brief. So let's, for the moment, rotate back to Judge Middleton.
All right, this is. Good morning, sir.
Good morning, sir. How you doing?
I'm doing all right. Let's see what we got here.
Hello.
What I'm doing, I'm checking to see if your lawyer, Paul Gibson, is here tomorrow. Jordan. Ross. There he is, Clayton Carr. He's set to be here tomorrow afternoon.
See you later. Yeah. Hey, sir.
Yes.
Is there any possible way that I can press charges? Because she knocked out my tooth and they had emergency move it this yesterday.
Say that again. You wish to press charges on who?
That's a picture for knocking out my tooth. They had emergency move it at the dentist yesterday. And then they had.
Well, I don't know. We'll find out. You got a lawyer. Let's see where the deal is here. They just handed me this. Let me look at the actual case. They allege that you violated the conditions of your bond. You are on a conditional release in this charge on some serious charges. The file number is 26-65. So let's take a look. Also here with me is Jeanette Jackson from the Public Defender's Office. They set this for 1:15, but I don't have time to do this at 1:15 because I have a big fat zoning violation case All right, you were arrested on or about January 13th for assaulting allegedly somebody named Tessa Pitcher in Park Township out on Marcellus Highway. Alleged that you made an assault with intent to commit great bodily harm less than murder by strangulation, which is a 10-year felony offense, interfering with a crime report, which is a misdemeanor, and you're charged as a fourth habitual offender, which makes this potentially punishable by up to life in prison. So, just a minute.
Strangulation. That's, sorry, that's, I have.
I'm looking at your bond, trying to find your bond. Again, I didn't have any time to prep this. It was just handed to me. But I'm looking for, it's alleged that you violated your bond by having contact with Tessa Pitcher. Apparently last night, or January 20th at 2:30 in the morning, Travis contacted and assaulted Tessa in a Super 8 motel room. That doesn't sound good.
No, me, sir.
Don't say anything else right now. I'm trying to see what this is set for.
No strangulation.
Well, it's set for a pre-exam next week, January 27th. All right. So they arrested you last night at the Super 8?
Yes, sir.
All right. All right, you have attorney Paul Gibson. I'm gonna set bond violation hearing. In front of Judge Pattison. With your prelim or pre-exam set for next Tuesday, January 27th, 26 at 8:30. Your bond is canceled. You don't get to go allegedly assault the person you allegedly strangled while you're on our bond. So I don't know whether you were intoxicated last night or what the deal is. Notify Mr. Gibson, who's your attorney, and he'll come see you at the jail. Were you still living out on Marcellus Highway?
Yes, sir.
Who lives there?
My cousin's girlfriend.
Your son's girlfriend?
My cousin's girlfriend. His
cousin's girlfriend. All right. Well, I don't know enough about this other than I'm just going to hold on to you until your hearing next week. Your bond was set in the amount of $2,000 cash or surety, which is pretty low for this kind of offense. And then it's alleged that you violated the conditions of your bond. So you've got a lawyer, you've got a court date set for next Tuesday. I'm going to set everything at that same time. All right, Mr. Gunter, we'll let your attorney know. Thank you, Jeanette, for waiting for that. All right, let's talk about what else we have. We have a dude that was supposed to be here at 8:30 for a drug paraphernalia charge. He's apparently driving here from Mount Pleasant.
So while he racks up the next contestant, Michael Groff in the chat is currently at the dentist office. Everybody send out prayers and good wishes for Michael at the dentist office, because the dentist needs to treat him gently today. Because assuming he's not too roughed up, tonight he and I are going to film the pilot for our new show that we're doing together, In the Blind. And if that all goes well, then we'll be able to drop that episode tomorrow. Barbara, if you'd be so kind, put a link in the chat to In the Blind, please. If you're not already subscribed over there, please do so you get notified when we drop the pilot and when we go live, which will be starting February 2nd, every Monday and Wednesday evening. It'll be a show unlike what you're seeing anyplace else, I guarantee you that. Because as the name implies, Michael and I will be going into that show live, blind. We have no idea what we're going to be talking about until our producer tells us what it will be. So it'll be a hoot. So join us there. And he's done. All right. Let's go back to Judge Simpson then.
It's 9 a.m.
Thank you very much, Your Honor. Thank you, Ms. Calloway.
Thank you.
Court calls case People versus Michael Krieger.
Raymond Cook for the people.
Both cases.
Just 1896.
Got it. Krieger. Not here. There's another case. Actually, he's got two other cases with warrants. Bench warrant will issue for defendant's failure to appear. Do you have a BAC on him?
0.053 as well as benzoylecamine and cocaine. Salisbury.
Bench warrant will issue. Bond will be set in the amount of $25,000. To give a 10% privilege, a warrant will issue immediately. Issuing the warrant instead of a show cause because of the nature of the offense, as well as the fact that he has another warrant, 2 warrants that are pending. Court calls case People versus Gregory Lockridge.
Your Honor, Raymond Cook for the people.
Ron Brown appearing on behalf of Gregory Lockridge, Your Honor. Mr. Lockridge, can you unmute and introduce yourself? Turn your camera on.
Mr. Lockridge. I see him there, but he's not.
Yeah.
I'll pass it.
Getting dismissed.
Well, he still needs to be here. Get him signed on. Court calls case People versus Elizabeth Lohman.
Your Honor, Raymond Cook for the people.
Sorry, Your Honor. Assistant Public Defender Natalie Pate with on behalf of Ms. Lohman, who is present on Zoom. Ma'am, can you please state your name for the court?
Yes, Elizabeth Lohman.
Thank you.
Thank you, Your Honor. Retrial, Your Honor. Ms. Lohman and I have been in contact. We need to have a further discussion regarding the case. She is HIDA eligible, and I believe this is the case that will be resolved. And I'm just asking for a brief adjournment.
February 4th, 2026, 9 a.m. Bond continued. The court calls case People versus Adam Martinez.
Your Honor.
Adam Martinez.
Thank you.
Assistant Public Defender Natalie Pate, Ms. Martinez.
Ron Brown appearing on behalf of Ms. Martinez, Your Honor. Your Honor, I'm requesting an adjournment of the case, and I'm asking you to consider giving him another alcohol monitoring device other than sober link.
I have a scram right now. I'm looking to get the sober link.
I had it reversed, Your Honor. And he tells me there's been no positive alcohol.
But he was also a .210 with a crash. I'm going to deny that request. I'll adjourn this out to February 4th, 2026, 9 a.m.
Judge said no, Mr. Martinez, so we'll talk before the 4th.
Okay, thank you.
You're welcome.
Court calls case People versus Elijah Matthews.
Your Honor, Raymond Cook for the people.
Ron Brown appearing on behalf of Mr. Matthews.
Sir, please state your name. You need to unmute and state your name.
Elijah Matthews.
Thank you.
Your Honor, I'm requesting an adjournment so that I can share the surveillance video with him in this case. the meeting.
February 4th, 2026, 9 a.m. bond continued.
Thank you. When I get it, I'll contact you, Mr. Matthews.
Thank you.
Court calls the case People versus Russell Norvell.
Ron Brown appearing on behalf of Mr. Novell, who's appearing in person. State your name.
Russell Norvell, second.
Okay.
Your Honor, I met with him. I still need to share some more video with him. I need to get the program installed. So can we get the February 4th date?
During this matter, February 4th, 2026, 9 a.m. bond continued.
So we'll set up.
Court recalls the case People versus Wally S. Salisbury.
Your Honor, Raymond Cook of the people.
This isn't a ring.
Your name?
That's Wallace Salisbury.
All right. Ma'am, you are before the court. This is an arraignment. You are before the court on the charge of operating a motor vehicle without security or insurance. You understand that, ma'am?
Yes, sir.
All
Your
right.
Honor.
That is a misdemeanor, punishable by up to 1 year incarceration, but also a fine not less than $200, no more than $500 plus court costs. You understand that?
Yes, Your Honor.
All right. This is alleged to have occurred on December 19th, 2025 at the location of East Michigan Avenue near State Street in Pittsfield Township, Washington County, State of Michigan. You understand that, ma'am?
Yes, Your Honor.
All right. First question I have for you is, do you want to be represented by the public defender?
Yes, Your Honor.
All right, this is a public defender case.
Ron Brown appearing on behalf of Ms. Salisbury. Waive reading, Tammy requests a new pretrial date and a PR bond. She showed up, so I'm asking for personal.
And then having no waive formal reading, standing mute, court will enter a not guilty plea. But we'll enter that not guilty plea. Pretrial in this matter will be adjourned February 4th, 2026, 9 a.m. Bond in this case will be set as a $5,000 personal recognizance bond on order standard conditions, including no assault behavior or possession of any weapons. You understand that, ma'am?
Yes, Your Honor.
There is also to be no possession of any alcohol, recreational marijuana, or any illegal drugs.
Yes, Your Honor.
Thank you.
To help me, go with Kristen and fill this paper.
Mr. Lockridge on. Court recalls the case People versus Gregory Lockridge.
Morning again, Your Honor, Raymond Cook of the people.
Ron Brown appearing on behalf of Mr. Lockridge. He's downloading. Oh, it's He's trying to get on.
He's on here, so I don't know what that means. Mr. Lockridge?
It's showing so it's not allowing me to touch it.
Only half the screen is showing, so it's not allowing him to touch the buttons.
He's got more of a problem than I can fix. I'll pass it. We'll call it up in the next block. Court stands in recess.
So yeah, I think Judge needed his recess there. Sounds frustrated today. I don't blame him, and that might be a legit tech issue that person trying to peer via Zoom is having. There's some issues out there this morning, specifically on the Google side. I'm amazed that we're not having issues on YouTube at the moment, to be honest. But let's what's a good place to go? Let's do this. Let's go, we'll stay in Michigan, but we'll go up to Wexford and see what's going on with Corey Wiggins.
Case number 26-25-OD, appearances counsel.
Courtney Lawrence on behalf of the people. Thank you, Your Honor. Taylor and Anna Carvento on behalf of Ms. Crowley, who is present and seated to my right.
And we're here for a pretrial. Is there any resolution to this matter?
There is, Your Honor. It's my understanding that the defendant will be pleading guilty as charged.
Ms. Carvento?
That is correct, Your Honor.
Ms. Cowley, have you heard what the attorneys have said the resolution in this case is?
Yes.
And is that how you wish to resolve it?
Yes.
Can you please raise your right hand? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
It's my understanding that you'll be pleading guilty as charged to operating while intoxicated. That is a misdemeanor punishable by a fine of not more than $500 and or 93 days in jail, revocation or suspension of your license, vehicle mobilization for not more than 180 days, and possible interlock during any probationary period. You understand those, the charge and the potential penalties?
Yes, I do.
Back on January 1st of this year, were you on probation or parole?
No, I was not.
Were you on bond in any file?
No.
Do you remember reading and signing the advice of rights form? It talks about your rights to an attorney and your rights to a trial.
Yes.
Did you understand those rights?
Yes, sir.
Most importantly, do you understand that you have a right to a jury trial, that by entering a guilty plea today, you'll be giving up that right and you won't have a trial of any kind?
Yes, I do.
Has anybody promised you anything in order to get you to plea today?
No.
Has anybody threatened you in any way?
No.
And is it your own free choice to plea today?
Yes.
Mr. Avento?
Thank you, Your Honor. We did review an advice of rights form this morning as well, and Ms. Crowley signed it.
I have one in the file.
All right, thank you.
Are counsel aware of any promises, threats, or inducements not made part of the record?
No, Your Honor.
Then Ms. Colley, to the allegation that on or about January 1st, 2026 in the city of Cadillac or Wexford County, how do you plead to operating while intoxicated?
Guilty.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So back on January 1st, had you consumed some alcohol?
Yes, I had.
And did you operate a motor vehicle after consuming that alcohol?
Yes, I did.
And was that in the city of Cadillac?
Yes, it was.
Were you stopped by law enforcement?
I
Or-
was already stopped when the law enforcement came on the scene.
All right. Explain that to me.
I was at a snowbank.
Okay. All right. Not on purpose, I assume.
No.
All right. Ms. Lawrence, are there chemical tests to support the plea?
There was a blood draw. We do not have those results yet, which is why as charged, but there was a PBT and that came back to 2149.
Mr. Vento, do you stipulate to use of the PBT?
We do, Your Honor.
Do counsel believe the defendants provided the factual basis in which to accept the plea and that the court rule has been complied with?
Yes, Your Honor.
As does the court, I find the plea is knowing, voluntary, and accurate. Ms. Colley, I find you guilty of operating while intoxicated. Do we need to set this over for sentencing, I assume? Substance
Your
use
Honor.
assessment? All right, so we will set it for sentencing, waiting a substance use assessment. Ms. Colley, just a reminder that your bond conditions continue.
Okay.
And you can go out to the front window where you checked in and get your next court date.
All right, thank you.
Thank you.
Judge.
Fairly quick and easy there. Let's go to Texas, head south, say good morning to Judge Stevens.
Versus.
Okay, so we have two different victims here with
Same.
that carved out two different crimes, three crimes, two in one victim's case and a third one. So you've got three different crimes alleged, two indictments though, and they're both second degree felonies. So your problem is compounded. And will this carved out of the same event?
Yes, Your Honor.
Same.
Yes, sir.
Okay.
It's all kind of-
All right. All right. We'll see you back in 4 weeks. Okay.
Thank you, Judge.
Next one is a plea.
Michaela Isaac. I know I'm pronouncing this incorrectly, but Brent, where's Mr. Turk? John, you raised your hand. You're not, you're John West. Oh, there's Brent. Brent, did you see John was impersonating you? Yeah.
It's kind enough. You probably do a better job.
He certainly seems shorter. How do you pronounce your first name?
McKay.
McKay. Oh,
You
I've
do.
heard of that. Yes, sir. 25 CR 1460 was called Michaela Joseph Isaac. You were here with Mr. Turk, your attorney, and the state's attorney. Does the defendant waive a formal reading of this indictment and the arraignment here? Can we proceed in a summary fashion?
Yes, Judge.
In summary, this indictment alleges three paragraphs, which is kind of unusual. All right. I see. You were charged with the third degree felony of stalking, which carries with it no less than 2, no more than 10 years confinement in prison and a fine up to $10,000. But the grand jury has indicted you in stalking in 3 different ways. Looks like by threatening to commit bodily injury on someone, threatening to damage their vehicle, and threatening to damage their home. So each of those types of threats are individually a violation of law. I understand. What are we going to do, Mr. Turk, on this?
She's gonna accept the 5-year deferred obligation.
What's the relationship to the victim?
Believe it's.
I believe new girlfriend of boyfriend.
No. I've been with the man for 13 years and there was ex and their stepbrother and stepsister. It's weird.
It's complicated.
Sounds weird.
Very.
But you knew that.
Yeah.
All right. So where are we going on? Allegation 1, paragraph 1. You got 3 different paragraphs here. Just doing one.
Yes.
Yes. Okay. And again, does the defendant waive a formal reading of this indictment? Can we proceed in summary?
Yes, Judge.
In summary, Ms. Joseph, this indictment alleges in paragraph 1 that on or about September 25th, 2025 in Jefferson County, Texas, you committed a 3rd degree felony of stalking. Do you understand what you were charged with here?
Yes.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range that is dealt with in this particular case?
So,
An agreement has been reached between the parties that you would be pleading guilty, not found guilty, but placed on a form of probation called deferred or unadjudicated probation, where you are not adjudicated guilty so long as you follow the terms and conditions of probation, which will be normal and customary for this type of offense. They include things like don't have any contact with the person, follow the law, things, much of the same rules that all of us here in this whole room have to follow. So there's no excuse for you not to follow these, and there's no excuse to fail. This would be for a period of 5 years. There would, among other conditions of probation, there is restitution that is owed in the amount of $4,683.51 to the complainant in this case, who's the victim. Is all of that your understanding of the agreement?
yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, guilty or not guilty? Ma'am,
Guilty.
are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1 here. Did you sign that document voluntarily? Did you understand it, discuss it with your attorney, or the contents all true and correct? State's Exhibit 1 is tendered into evidence.
Objection.
And without objection, it's admitted. Among other things, this states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true at state, so help you God.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. Is this your signature right here?
Yes, sir.
That's it?
Yes.
You write like a lawyer.
Maybe I could find some time to go to the school.
Well, that thing just stretches right out there. It looks like some kind of an art form. A lot of letters in there. All right. Anything else to add? If not, I'm going to make the findings that, Joseph, you are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this third-degree felony of stalking. But I'm going to follow this agreement and defer or postpone any finding of guilt so long as you follow the terms and conditions of this probation order. The probation officer will be going over all of this with you, and you will sign it if all is well. And you are going to be placed on this deferred or unadjudicated probation for 5 years. You must pay restitution to the victim in an amount of $4,683.51. There will be other terms and conditions of probation, which include don't have any contact with the victim nor anyone on your behalf. You don't know this person, or you're not keeping tabs with her.
We should say
Huh?
that kid that,
I've already told her, Judge, just call the police if she's having issues with her, if she's in her home. Don't go around her, don't have anybody else with her.
You don't want to foul things up here, because if you fail, your probation could then be revoked. You could then be found guilty of this third-degree felony. And when you're found guilty, it lasts for your whole life. And then you can be sentenced up to 10 years in prison. You don't want that. Let me ask you on this restitution, how are you going to pay that back? How much can you pay monthly? Because you probably can't write a check for $4,683.51, right?
I can probably get my mom to help move like 78.
Well, your mother didn't responsible for this. This is one of those things adults have to handle responsibility.
Well,
You need somehow it needs to get paid back. How much can you pay back per month? Yeah, I know you can't write a check for it right now, but I want to know how much you can pay per month so that we can figure out.
Probably 80 a month.
Ma'am, 80. I will start off with that. No less than 80 a month, but see, in 12 months, what's 80? $960. So that's in a year, that puts you still 4.5 years away from completing this. But then you're on probation for 5 years. We shorten probation, by the way, for good behavior and taking care of all your responsibilities, including restitution. Every day I dismiss early deferred probation orders.
I will have it. I probably have some.
That's going to be I think all these other provisions, you're going to be able to figure out and follow, or else, that's not good, because these are all, like I keep telling people, most of these are the things I have to follow, the same rules we all have to follow there. So it's not unusual or uncomfortable, but restitution is going to be different. Okay. Here's the restitution order. I'm going back to the probation office. Please sign those. You begin and do well. Thank you. Good luck. Steve Savoy.
Judge, I just recently got some discovery with it. I'd like some time to go over it with him. Possible.
When did that happen? When did you?
I want to say within the last week or so.
Well, that was recent.
I know, Judge, I'm slacking.
25 CR 1527 is called Steve Dillon Savoy. You're not the Grove Savoys, are you?
No, sir.
I grew up with the Grove Savoys. All right. You're charged with a state jail felony of child abuse or neglect. This carries with it, if convicted, up to 2 years in the state jail. Is very serious. What are you asking for, Mr. Pearl?
Can I get 45 days?
You got it. That's about 6 weeks.
Yeah, roughly, yeah. We're gonna give you a reset down the stations. What's that? That should be good. I think that. Oh, no, something. That's the problem.
Hold on. We're not through it on this one. Come on up, everybody.
They're gonna get you a reset. Say,
All right, this is,
oh, we're not done yet, sorry.
yeah, we're not done.
Oh, sorry.
What's the situation on the issue of the child? What's the relationship?
Your Honor, I don't believe there's any relationship. The facts of this are a bit unique.
Williams supposed to be supervising a 4-year-old, but it's not your child?
No,
Why were you taking care of this child?
I was not, so.
Did the grand jury make this stuff up? I mean, they have some reason for it. Do you know what we're talking about here? Do you know the subject matter?
Yes, sir.
Your Honor, it was a false report. It wasn't an injury to a child.
The defendant claimed a child was unsupervised. Dead animals were accessible to this child. The front door of the residence was left unlocked and the child was going hungry due to a lack of food in the home. So the defendant, it's alleged the defendant called law enforcement or authorities and made these allegations. That's what the grand jury alleges,
That's correct, Your Honor.
which were deemed to be allegedly false.
Yes.
Okay, and if this occurred, then what happens is if this actually occurred, then the crime is filing a report that caused authorities to take action when there was not a valid basis for it. Because we're all busy doing other things that we're supposed to do, and we don't have any reason to be running off to wild hair chasing. So. It says the defendant submitted a report to Child Protective Services. And he was hired to remodel their home. And there was a disagreement. Asked not to return to remodel the home. And then later on, claims he observed neglect of the children. That's what all of this says. Have you heard about this?
Yes, sir.
All right, your glasses, 6 weeks.
Okay, just quiet.
Okay, we're resetting. Therese Simeon.
Yeah, all those places now.
Nope, I'm already there. You don't need that.
Thank you, Jeffrey.
Judge, I have the media on this, but I don't have the witness message for some reason.
Sorry to hear that.
Yeah, me too.
25 CR 1528 is called Therese Shante Simeon. Is that you?
Yes, sir.
And you were charged here with this indictment that was filed not long ago with the second-degree felony of burglary of a habitation, which carries with it no less than 2, no more than 20 years confinement in prison and a fine up to $10,000. So it's serious. What do you want to do today?
Judge, I need to get it reset and get.
You need to get it reset. How long?
4 weeks, fine.
I can only give you 4 weeks.
Witness go. Let me just,
It's 4 weeks ago?
yes, sir.
Okay. Get it reset in a sec.
Send me, yeah, I'm gonna take it.
Alberto Toledo the third. 25 CR 1. That's awesome. 803 is called Alberto Toledo third. No answer in the courtroom. I asked the bailiff to call into the hallway for into the mall. Sometimes I think we're at the mall. Alberto Toledo the third.
Yeah.
You recognize anybody at all?
No response, Judge.
There's no response to that name being called in the courtroom. No response to the name being called in the hallway by the bailiffs. Defendant has failed to appear. His bond is $10,000. It is revoked for failure to appear. The bond is now doubled to $20,000, plus the defendant shall be required to have a GPS device at all times, so we know where he is when he's not in court, when he's supposed to be here, and a warrant shall be issued for his arrest. Okay. Dazani Matherson.
How are you?
That's John West. John, there you are.
Yes, sir. Yeah, that's fine.
25 CR 1665. You were Dazani Matherson?
Yes.
Here, is that yes?
Yes.
Yes, so she can hear you. You were here with your attorney, Mr. West, and the state's attorney. You were charged here with the third-degree felony of stalking. We have another stalking case. What's going on out there? A lot of stalking. If convicted, this carries with it no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Are you familiar with the circumstances we're talking about, ma'am? Well, whatever happened there, it resulted in the grand jury indicting you. So that's why this is serious. Are you employed somewhere? Are you employed somewhere? You have a soft voice.
Yes, sir.
Where?
Okay.
That trailed off.
Yeah, you gotta talk really loud.
Yeah, I know you talk louder at Taco Bell. Come on, so people can hear you. All right. Once again, this carries with it up to 10 years in prison, and it'll ruin your job opportunities if you're found guilty. So you need to work through this responsibly. What do you want to do today?
You're on an initial appearance, if we can set up an announcement docket so I can get the discovery, go over it with my client, and then see if we can resolve this.
All right. Is there anything? Well, let me ask you, you're familiar with what the allegations are here?
Yes, sir.
Okay. You can't have any contact with this person that's alleged to be the victim. Do you understand? You understand? You have to speak out to me. Okay. Nor can anyone on your behalf go and contact her. Do you understand? That can be more trouble. You don't work with this person, do you?
No, sir.
Okay, well, if you work, I mean, you'd have a problem working with him. All right, get a reset.
All right, I think it's time to switch things up. Let's go back up to Michigan. Spend a little time with Judge Mom.
Happened alongside defendant Caleb Dobson, present this morning for a scheduled sentencing and bond violation matter.
All right, thank you. And sir, your name for the record, please.
Caleb Dobson.
Okay, and thank you for dressing appropriately for court. All right, so originally, this matter was scheduled for sentencing November 12th, and this is on your client's plea to an amended charge of operating while intoxicated first offense. It had been reduced, the 2 original charges of operating while intoxicated second offense had been dismissed. We originally scheduled this for sentencing November 12th. It was not scheduled, or we did not conduct it because your client was interested in sobriety court in the 17th District Court. It appears as though there was outreach attempted by the 17th District Court sobriety court to no avail to your client. And so then we were set for January 7th. We did not call the case on the record. You were set to be in another court, and we were running behind in our docket. It was extremely large that day. And then you indicated you're still working with treatment court for your client. Which treatment court was that?
So, Your Honor, I had initially followed up with the 17th District Court. I was in contact with the clerk from that court. She did advise me, though, regrettably in January, following our last appearance for you, that they were no longer accepting transfers, and so we weren't able to proceed with 17th District Court. However, after speaking with Ms. Shaw from the probation department, we did also begin to make contact with Harper Woods. However, they did not indicate a response. In terms of acceptance at this point, we would need to go through a more formal screening process with them as well. So we did make some efforts. And if Your Honor, if I may expand on the efforts, both in terms of what Mr. Dobson received from 17th District, as well as there were follow-up efforts on his part that are not necessarily noted or reported in the PSI, but I can speak on that as well.
Okay, well, a couple things. So, so here, counsel, is my question. So you have Harper Woods that you've reached out to on behalf of your client. When did you reach out to Harper Woods?
Just prior to the holiday, I received the response from 17th District Court that they were not accepting transfers on January 12th. From there, I did follow up with both Ms. Shaw as well as make a telephone call to the sobriety court, treatment court in Harper Woods. And I was awaiting response to information. And then unfortunately with the MLK Day closure this past Monday, that kind of further delayed a more formal response. So that was something that we were looking into. However, with respect to that, we are also to the extent or degree that we are able to, as it relates to the Dearborn Heights matter, we have been in contact with that court as well. And we are prepared to make arrangements through them with respect to help securing a transfer into a.
So tell me about the outreach from the 17th District Court that indicates that your client did not respond. And I will note, here's that sentencing was adjourned on as defendant was interested in sobriety court. This was from the November 12th date. Then it says defendant did not respond to calls / emails from 17th District Court sobriety court. Note, defendant expressed interest in the same sobriety court in July with no further contact at that time as well. So did you seek, well, right, because you were arraigned July 7th. So part of the problem that I'm having, counsel, is that it appears as though the attempt for sobriety court by your client has been ongoing for 6 months. 6 months. I run a treatment court in this court, mental health treatment court. I know that it does not take 6 months.
Of course.
For somebody to complete screening, have eligibility determined or otherwise. So why is it taking 6 months?
Yes, Your Honor. Certainly I can speak on that. And I would just note for the record as well. So I, as retained counsel, was substituted in on or about December 15th. So in a large sense, I've been playing a little bit of catch up with respect to the history of this matter. I note that only to say, from what I've learned from both speaking with Mr. Dobson from the other courts and seeing some of the communications, namely that being some emails that Mr. Dobson had received after the original sentencing date, he had received a new email from Redford at the very end of November, where they, again, that was an email where they go through the various phases and such. Mr. Dobson did show me a call log where he did attempt to call them several times in December to be responsive as part of that process, which I understand is much later than July.
I understand, but let me just ask a follow-up to that. Why didn't you just respond via email, sir?
Why didn't? Why, she was asking why you didn't respond via, to their email. Your Honor, if I may just very briefly interject before I allow Mr. Dobson to further respond to the question. One of the things that I've learned, and particularly at the end of December and early January, and I actually learned a great deal of this from Mr. Dobson's mother, who was able to be present on January 7th, because she does now live out of state. I've learned that Mr. Dobson has several very significant intellectual and learning challenges or disabilities. And I believe from speaking with Mr. Dobson and his family that those challenges or disabilities very significantly impacted his understanding, both in terms of document intake completion, understanding what his obligations or responsibilities were. Mr. Dobson has explained to me that over several instances or courses, primarily closer to July, when he did first express interest in this, he was under the impression that it was the appointed counsel at that time that was in coordination with the court. I understand that he should know that it is his responsibility, that he does need to be responsive and engaged. I would say that he's certainly in that frame at this particular time. Unfortunately, from about July up until October, he operated on a faulty understanding, a faulty belief that it was the appointed counsel or his attorney was the individual to be in coordination for screening purposes. I've explained to him how that is a misunderstanding. I have explained to him how he does have to be responsive, that he has to go through the screening, that can't be done for him, things of that nature. So since I've engaged with Mr. Dobson and have worked extremely closely with him, I do believe that there has been a very significant change and development in his own understanding of what these circumstances are, what sobriety court means, entails, what his obligations and responsibilities are. And this is with absolutely no disrespect to his former counsel. I think there was a night and day difference in terms of what he understood then versus what he understands now. And I've tried to work very closely with him, understanding those challenges or disabilities that are impacting his understanding, his reading, his completion of these documents. So I'm right there with you, Your Honor. I know that sobriety court is a process that it does entail to go through the screening, but it should not take 6 months. I only wish that I could have engaged with Mr. Dobson that much earlier to be that much more involved with him, to have ensured that this could be done timely and successfully. But
So what are the, you indicate there are some intellectual disabilities for your client. What are those?
So Your Honor, Mr. Dobson has been formally diagnosed with ADHD, obsessive compulsive disorder, with I think a more extreme or significant qualifier that they've attached to it. Now, I've worked really closely with his mom to try to understand the more technical or formal terminology, but he has been diagnosed as he and his family have described it as slow learner. He's been on lifelong IEPs throughout his entire schooling. I was trying to get copies of that, but unfortunately, I wasn't able to receive that. His family hasn't preserved from his high school and lower education, but they have noted to me, Mr. Dobson's been very forthcoming with me, that as difficult as it is to talk about these challenges, because he's very proud of himself for being able to be successful in school and overcome them, but they are very significant. And so I wish I had a more formal term than slow learner, as his family has called it, but they have acknowledged to me that he was on IEPs from an extremely young age up and through the completion of high school.
And was that from the ADHD diagnosis or from a learning disability?
I think it's from the learning disability, Your Honor. I think the ADHD is secondary, but that I did want to acknowledge that one because I do have the more formal terminology for that.
Okay, and sir, how are you doing in your classes regarding electrical engineering?
I graduated, Your Honor.
Okay, and so when did you graduate?
I believe I Terrible months. I believe it was, October.
October of 2025, Your Honor.
Okay. And so, when you graduated, did you graduate with a diploma, a certificate,
A diploma.
okay. And so what was your grade point average when you graduated?
It was a 3.5.
That's great for electrical engineering, because that makes my head hurt. Right?
Your Honor,
So-
he's doing extremely well.
Yes, and that's
Good
great.
Job opportunity that unfortunately they had to rescind just due to the pending matters, but they did, the individual we spoke with did indicate that, at the right time in the future, if he's still interested, they will be happy to take him.
Okay, and that's good, sir. I ask those questions, counsel, because I also have children that have, one has ADHD, another one has learning disability. That's never once, been utilized as an acceptable excuse to not follow directions or to not understand something. And I would beg to disagree that your client, didn't understand some of what his responsibilities were. Perhaps he may not understand the criminal procedure, although I also find that hard to believe since this is not his first time, especially with this offense. And so I can understand your client has had some learning challenges and whatnot, has had IEPs, but I do not find that that's an excuse or an acceptable excuse to have prolonged the treatment court for 6 months.
Absolutely. And Your Honor, I only interject just to be very clear in this particular point. I'm not trying to provide this as an excuse or to otherwise explain Mr. Dobson's failures in that regard, but rather I simply provide it for context. Because, quite frankly, Your Honor, what I do think is significant and noteworthy is there are additional efforts I have not necessarily been able to provide on the record quite yet, but there are other efforts that Mr. Dobson has meaningfully self-initiated following December 15th and the substitution of counsel that I do think speak to the change of understanding, the change of both appreciation and engagement. To that point, Your Honor, Mr. Dobson has commenced both a course of AA participation. He has been attending AA on a regular basis since December 23rd, Your Honor. He also had engaged and reached out to counseling. Unfortunately, he wasn't able to complete a counseling session because after enrolling and engaging, they rescinded because they wouldn't accept his insurance, and he doesn't have sufficient out-of-pocket funds to only go through insurance. So we were either through the court, through sobriety court, or otherwise seeking to find support in that sense. But he has engaged in several efforts that are self-initiated with the assistance of counsel. And so I have, fortunately seen significant turnaround in short time. I understand that's a much shorter window of time compared to the period prior, but I do think that the efforts he is engaging in at this time are reflective of a renewed, deeper understanding and appreciation.
Okay, and I can appreciate that, counsel. So my question is this: has your client contacted his insurance company for a list of treatment providers that accept his insurance?
That's what I was currently about to do.
About to do. When did you begin your quest for treatment? And last week?
Last week.
Last week was the last update from them. I have worked with him much earlier on. I think part of the delay with going through his insurance to find other providers was in large part because when he first connected with this particular provider and they had indicated that they take his insurance, and he had ceased looking elsewhere because he was operating on the response indicating that they were working with him or scheduling with him, only to then be told that they weren't taking his insurance and that he needed to look elsewhere. His father has excellent insurance through Ford, right?
Yeah.
Through Ford Motor Company. And so they were beginning to explore what options are available through that as well.
I also like to add, Your Honor, as so silly as it may sound, I did not think to call my insurance. My mother-in-law told me, hey, you should call your insurance. So that's why it took now. Someone had to bring it for me, and that's why I'm gonna do it.
You're married?
No, I'm not married. It's just easier to call her that.
His girlfriend's mother's. He and his girlfriend do reside together now. It is truly like a partnership. Mr. Dobson is quite young, but what I found from speaking both with him and his partner is they are the quintessential older couple in a younger body. So they are not married, but very much my impression is they live very much like a married couple.
Okay. So let me do this. Well, at what stage council is, so let me, hear how I ask my questions because I'm not sure if we're going to, well, what's your plan for the bond violation?
So, Your Honor, I did want to advise the court that I was contacted, but just prior to MLK Day from the officer in charge out of Dearborn Heights, that charge was just filed. I have filed my appearance with them. They did set an arraignment date, albeit the court set that arraignment date for February 27th. However, I've been in contact with the court. They've advised us that we are able to appear on any Friday for purposes of having Mr. Dobson arraigned in the 20th District Court. My request to the court for sentencing or for bond violation was if the court were to place Mr. Dobson on a period of probation so that the court maintains strict oversight and conditions over Mr. Dobson, we are in a position where we can have him arraigned perhaps this Friday as we were beginning to talk about. So I did want to advise the court that as it relates to that matter, we have engaged with that court. We are responsive to that court. We are planning to have Mr. Dobson arraigned. So I don't know if the court is either inclined to place Mr. Dobson on a period of probation or would otherwise prefer to provide one more brief adjournment for purposes of addressing that, following up on the Harperwood Sobriety Court or counseling for purposes of ensuring Mr. Dobson has adequate rehabilitative resources.
So I'm not opposed, counsel, to setting out the sentencing one more time to perhaps for you to reach a global resolution as far as both cases being referred to sobriety court. Here's a couple challenges though. One, your client lives in Redford. I don't know how easy it will be for him to get to Harper Woods. So that's something that needs to be looked at. There's also a sobriety court in Dearborn in the 19th District Court. I don't know if they have any openings or not. So I suggest those, since those are a bit more geographically convenient for your client. I was intending on conducting the bond violation today. I don't know if you've spoken to your client regarding the bond violation and whether or not he's wanting to set this for a hearing or if he's pleading guilty, what that looks like. I don't know what you've indicated.
Your Honor, I have had an opportunity to speak with Mr. Dobson. The nature of the violation, as he and I have discussed, I do not believe is necessarily appropriate for a hearing. Mr. Dobson is prepared to respond to the violation allegation. And very much, as the court indicated in the inclination, we are hopeful that the court would provide that opportunity for a global resolution.
Okay, so I'm going to arraign you on the bond violation. And obviously the bond violation is that you violated bond by, it's alleged consuming alcohol in Dearborn Heights and then arrested for operating while intoxicated, third offense. And further, that you were at the same time also arrested for driving while license suspended. So those are the charges that are, sorry, Alan, that are alleged for the bond violation. So I'm going to indicate a plea of not guilty. And counsel, it would behoove you and your client both if you can take your client, get your client into the 20th District Court sooner than later, because I'm only going to go out 4 weeks. That gives you time to handle the arraignment, the probable cause conference, speak to whoever you have to speak with at the Wayne County Prosecutor's Office, and communicate with the treatment courts that you're looking into.
Thank you, Your Honor. We appreciate the court's consideration.
Mr. Dobson, how'd you get here today?
Uber.
How much did that cost you?
Honestly, I didn't even look.
Well, pull out your phone. Pull up the app. Let's see what it says.
It was $30, Your Honor.
What are you typing in there, sir?
Oh, no, I was on Chase. I was looking at them charging me.
Oh, I wanted you, okay, I was having you pull up the Uber app.
Yeah. Yeah, use that.
Does February 25th work for you both?
Yes, Your Honor.
Does the afternoon work, counsel?
Yes, Your Honor.
Okay. 1:30 p.m.
Yes.
From the Uber app pulled up?
No, it's not pulling up.
And here's what the court's going to do as well. The court's going to amend, let me see. Amend your bond condition to include an alcohol tether. Actually, we're going to do a sober link, and you're going to test 6 times a day, sir.
Thank you, Your Honor.
I have some serious concerns for the safety of the public. So I find that that will be one tool whereby testing every 4 hours will give this court some confidence that you're not consuming alcohol. No kratom, nothing, no substance, sir, unless it's recommended by your treating physician.
Yes, Your Honor.
No kratom, no anything that you can buy in the store that has hallucinogenic changes, some opioid-like responses. Nothing. Stop over at probation. Somebody will be with you shortly to give you information regarding the sober link. Okay.
Thank you, Your Honor.
Thank you, Your Honor.
And just be aware, counsel, I am not inclined to adjourn because there's not been a response by the Wayne County Prosecutor's Office, or there's not been any outreach to the treatment courts. There's a multitude of different treatment courts you can reach out to. I've given you 5 weeks.
Your Honor. Quite frankly, I would not dare ask for another adjournment, even just looking at the record, understanding, the circumstances. We are very prepared to make sure that we are promptly able to resolve this.
All right, very good. Thank you. Have a good day.
Likewise.
All righty, friends. Let's go down to Louisiana. See what's up with the board today.
Morning, sir. This is the Committee on Parole. It's called to order. The date is January the 21st. The time is 9:08. My name is Carolyn Stapleton. I will serve as the chairman on today's panel. We'll be joined by Zoom, Mr. Steve Prater and Miss Jerry Ledoux. Okay, quarter staff, will you please introduce yourself for the record?
Devin Cavalier.
Carl Williams.
Francis Abbott.
Okay, and today's remote location is going to be at Rapids Detention Center. Staff there, will you please introduce yourself for the record? Is there any staff in there with you, sir?
Yes.
Sergeant Stommel.
Okay, Sergeant.
Yes, ma'am.
Sergeant Stone, you said?
Stommel.
Okay, thank you very much.
Yes, ma'am.
Okay, for the record, Mr. Williams, will you introduce yourself and give your DOC number, please?
My name is Clem Williams. I don't know my DOC number.
Okay, that's okay. I've got it right here, no problem. It's 793-125, okay?
Hey, thank you.
Okay, you're more than welcome. Okay, well, I'm gonna read some information, and and at the end, you can verify that it's correct, okay?
Okay.
I'm just gonna repeat a couple of things you just said, that your name is Clem Williams II, and your DOC number is 793-125. You're a first-class offender. Your offense is aggravated second-degree battery. You were sentenced to 6 years hard labor. Your parole date is December the 4th, 2025. Your good time date is July the 10th, 2026. You have a full term date of January the 10th, 2028. Is all of that correct, sir?
That's correct.
Okay. Will you please tell us why are you incarcerated and why should you be released early?
I know I'm not all the way there since I've been in jail. I have gotten treatment. I know what I did was wrong, and I'm sorry. If I could change it, I would. And I know that if I'll given another chance, I would do good.
Okay, sir. All right, Sergeant, do you have anything or any comments you would like to add as to his time that he has spent in jail there?
No, ma'am, we haven't had any problems with him or anything.
Okay, you've had no problems.
Yes, ma'am.
Well, today you don't have anybody in support for you, but you do have opposition. And that would be District Attorney Philip Terrell. And you can get up and speak.
Yes, ma'am.
Thank you, Madam Chair.
Uh-huh.
Members of the board, thank you for the opportunity to address you. I know each of you have thoroughly reviewed this case, so I'll try to be as very brief as I can be. The facts in this case are fairly heinous. Mr. Williams was arrested for attempted second-degree murder, and he pled guilty to aggravated second-degree aggravated battery. Sentenced to 6 years in plea bargain. Of note, as referenced at one point, the facts were that Mr. Williams was a patient at Pinecrest, at Pinecrest State Hospital. And he had attacked another patient there, and he was after detectives reviewed the video surveillance, it occurred after the other patient you did an obscene gesture to Mr. Williams. Mr. Williams stabbed him in the back of the neck with a pit cone, a metal pit cone, repeatedly, at least one time. And last time it stuck in the other patient's neck. Staff broke them up, and as members of the staff were attending the other patient, the victim, Mr. Williams broke away from staff that was trying to restrain him and pummeled him about the head and shoulders and was trying to hit the pick, according to the staff. according to the police report. I know that y'all have read all that. Mr. Williams said, and there was some question, there was a sanity commission filed by his counsel, and he did go to the DOC facility and was examined there, and it was determined by the a sanity commission that he was both able to stand trial and not mentally incapable legally at the time of the commission of the crime. Mr. Williams admitted to both the Pineville Police Chief, Pineville Police detectives, and to staff that he intended to do it, which was apparent from the video, that he would hurt somebody again if he did not get what he wanted. He wanted to be moved to a facility or a halfway house near New Orleans, and he told numerous times, and I won't bore y'all with all of them, but numerous times he said that he would, when he doesn't get what he wanted, he would hurt somebody. In fact, he said in response to Dr. Woods and Dr. Woods and Mr. Williams told Dr. Wood, who I presume is a DOC, but let Clem tell you all something. I will keep hurting people until I get what I want, and I don't need any more warnings. And at one point, he told Mr. Williams told the doctors, I don't give an expletive no more. You can send me to jail. I told Connolly that I was going to do it, go into jail for the fourth time, this time for attempted murder. Then he says, in closing on in that interview, I don't want to be here. That was a warning. I talked about stabbing that expletive in the neck, and I wanted that expletive since yesterday. I asked Mr. Williams if he was trying to kill the victim. He stated yes. And this is a police interview with a pilot detective, I'm sorry. So he said, Mr. Williams, why did you do that? He just bothered me. I wanted to teach him a lesson. So the diagnosis that I want to point out to y'all, I know that the gentleman's mental state was an issue. I know that y'all may be thinking about that. As one final point, Clem's intellectual disability is correlated with, but not the cause of challenging behaviors. Clem's presentation is most consistent with his diagnosis of antisocial personality disorder. Specifically, Clem exhibits a lack of remorse, aggressiveness, impulsivity, and disregard for the safety of others, which supports a diagnosis of antisocial personality disorder. This critical incident is of salient severity, indicative of Clem's focus on achieving a discharge from future progress. And once again, to me, the part that's most telling is Mr. Williams' statement in writing. But let Clem tell you all something. I will keep hurting people until I get what I want, and I don't need them anymore. Ladies and sheriff, I would submit to you that we're 2 years into a 6-year sentence of a very bad crime, and Mr. Williams got a pretty good deal. And he got that pretty good deal because of various factors. It was clear, we had a victim that it was on video, but we had a victim that has a severe disability, so can't testify. And there was the obvious element of the mental situation. So we did a plea bargain, and he got a good deal. 6 years for this very aggressive and pretty much heinous act, which had the police arrested him for attempted second-degree murder, which would have put him in prison for 50 years if we would have did. So in any event, I would submit to y'all that he's only been in jail 2 years. I would submit to you that's not enough time for Number one, we need to protect society. We need to make sure that he's ready when he gets out to become a productive member of society and not be the person who says, if Clem don't get what he wants, he's gonna hurt somebody else.
Mm-hmm.
So in summary, I would submit that it's not time for him to be paroled for a variety of those factors. And I appreciate y'all very much letting us come address you today. If there are any questions from any of the board members, I'll be happy to try.
No, I mean, I noticed the very same statements that you gave me, and I have them marked in the police report that I have too.
Yes, ma'am.
I don't have any questions. Do either of my colleagues have any questions for the DA? No, Ms. Ledoux doesn't. All right, well, we really appreciate it.
Thank you so much.
Thank you. Okay, the case has been assigned to me, so I will conduct the interview. And then later I'm going to cast the first vote. I made note of exactly the same things from the police report that the DA did too. That you were going to continue to hurt people until you got what you wanted, and you didn't need any more warnings. And you told him that you were going to do it, and you did go back and try and continue to hurt him after staff was trying to help him, and you had stabbed him. And then when you were asked why you stabbed him in the neck, you said that you wanted to teach him a lesson, and that you intended to kill Mr. Khan. Well, the other inmate or the other person. Did you intend? And you said yes, that you did, and that you tried to kill him because he flipped you off. Does that sound familiar to you, sir? At the time?
Yes.
It does, okay. Okay, so you heard the DA, I've got the same report. Do you have anything you'd like to add to that? Or take away, or?
No.
At the time?
No.
Okay. All right, well, I'm gonna ask my colleagues. Ms. Ledoux, do you have any questions?
No, ma'am, I've reviewed the file and listened to the testimony.
Okay, Mr. Prater, do you have any questions?
No questions.
Okay, well, at this time, we're prepared to vote on the lead vote. So, I'm gonna deny your request for parole, and on the facts of, I consider you a continued public safety. You have only served 2 years of the 6-year sentence, which was very like what, according to your words at the time, was actually attempted murder. So not enough time for a deliberate crime of violence. Number 2, law enforcement and judicial opposition completed. And number 3, at the time I saw no lack of remorse for the crime. So, Ms. Ledoux, do you have anything?
I concur, Ms. Stapleton, and my vote is also to deny parole.
Okay, Mr. Prater.
My vote is to deny parole based on the degree of violence, not enough time served, a danger to society, and law enforcement opposition.
Okay, the outcome, Mr. Williams, is that today your request has been denied. And the time is 9:22, and we will be closing from this facility.
Denied to the shock of nobody, I would guess. It's TCF Live on a Wednesday. I hope you're all enjoying yourselves today and having a good day, at least so far. And if it's not good, I hope it gets better. And if it is good, I hope it continues to be that way. Let's rotate over to Texas. Judge Boyd.
Patrick Bettis for Dominic Smith, Your Honor.
And are you Mr. Smith?
Yes.
All right, counsel, have you received all discovery in each of these cause numbers and did you review it with your client?
Yes, Your Honor.
And each cause number, the court will find that the state is in compliance with discovery. Mr. Smith, in each cause number, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, in each cause number, do you waive the reading of the indictment?
We do, Your Honor.
State, in the cause number ending in 6-5, are you proceeding on the indictment as presented?
Yes, we are, Your Honor.
And in the cause number ending in 3-6, are you proceeding on the indictment as presented?
We are not, Your Honor. We are proceeding on count. We need amendment on that one. We'll waive counts 1 and 2.
No objections, Your Honor.
And Mr. Smith, in each cause number, did you review the application for deferred or community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
In each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? And cause number 2025 CR 014065, you're charged with violation bond or protective order 2 times or more within 12 months. And in cause number 2025 CR 014136, you're charged with stalking. These are third-degree felonies. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand?
Yes, ma'am.
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. By entering this plea, you're giving up those rights. That you intend to give up those rights and enter into pleas in each of these cause numbers. In each cause number, did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you to 10 years in prison in each cause number and up to a $10,000 fine? Did you understand? Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he is currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Smith, in either of these cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering into these pleas, you will be deported, denied naturalization, and re-entry. Did you understand? In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes.
In cause number ending in 6-5, according to the plea, punishment is to be assessed at 6 years in the prison. There's a $1,500 fine. State is opposed to your applications. This will run concurrent with the case number ending in
Now that you said, I think I need to fix that.
all right. Any objection to the court just correcting that?
Yes.
All right. No problem. This is the run concurrent with 2025 CR 014136 and 2025 CC 014639. The state is taking in consideration 2025 AL 001293 and 2025 AL 002994. And there's to be restitution, if any. And there's to
That loss of audio is on her end, not ours. Let's
and the cause number
okay, she's back.
ending in 36. The state is proceeding on count 3. Punishment is to be assessed at 6 years in the prison. There's a $1,500 fine. State is opposed to your applications. This will run concurrent with 2025 CR 014065 and 2025 CC 014639. They're taking in consideration 2025 AL 001293, 2025 AL 002994, restitution, if any, and the same no contact orders. Did you understand that to be your plea in each of these cause numbers? Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney in each of these cause numbers? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, are there any such motions?
There have not been, no.
Then in cause number 2025 CR 014065, how do you plead? Guilty, not guilty, or no contest?
No contest.
To count three in cause number 2025 CR 014136, how do you plead? Guilty, not guilty, or no contest?
No.
State any evidence.
Mr. Chairman, with regard to both cases, they will offer into evidence if exhibit one, public fact.
No objections, Your Honor.
All right, and state, have you spoken with the complainants? All right, thank you. State, you may be excused. In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you and confront any witnesses the state will call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand? In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
All right, friends, while we wait for her to review, reminder, tomorrow night, sidebar, 8 p.m. Eastern, 5 p.m. Pacific. We had a good discussion last night about the idea of committing crimes when it's necessary for life and how that should be addressed and punished. And we kind of went off on a good tangent, I thought, about waste and how rather than helping people, there's a lot of waste going on. And I actually have a little bit of information on that to share with you in the fourth
In each
hour.
cause number at the review and states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt in each cause number as you apply for deferred adjudication. All right. Counsel, if he wants a full PSI, it's going to be about 8 to 12 weeks. If he would like to come back sooner, if you waive PSI, what will end up happening is I'll give you a chance to have whatever witnesses or whoever you want brought in to testify or whatever evidence you want to present to the court. But otherwise, it'll be 8 to 12 weeks for a PSI and TAP evaluation.
Mr. Smith is very motivated to get out, so the sooner the better. And yes, will there be any, you'll just have some confirmation of his record or anything from the PSI?
The state will probably most likely give me any type of criminal history. But what I can tell you all, I'm reading the stipulated evidence. Do you think he needs a MIC evaluation at least?
He's a veteran, spent 4 years in the military.
Mhm.
And on a particular date, I don't have the date in front of me, Your Honor, he had a motorcycle accident, which his case is pending.
Mhm.
So there was a TBI involved. So I have a volume 1 of his medical that I was going to try to succinctly place before your honor.
Okay.
And the better news is he has grandparents who are here present. They've been very active through the case this entire time, very supportive. If we were to be granted probation, he would reside there immediately. The same day or the following day, he's going to be in with the doctor to get the appropriate medication to assist his situation. And will have the resources, we think, based on the accident, resources that we think we're going to get as a result of the traumatic brain injury accident. And so none of these things are going to occur in the future. He's going to be a stable resident. He's going to receive the right medication. He's going to have just a new outlook. He's been, very remorseful about this whole entire situation and what he did. And, he realizes the situation he got himself in. He spent almost a year in custody and he's just very motivated to get out.
Okay. So, that's information you may want to let the state know. So do you want a MIC evaluation? If there's a MIC evaluation done, how long would that take?
Judge,
Would it still be 8 to 12 weeks?
Judge, I could probably get it done in 6 weeks.
Give me one quick second.
Sure.
Regarding a MIC evaluation, we've already, in the volumes of information I have, there's already been an evaluation. That'll be some of the testimony that we'll provide to the court. So we could have just a shorter time frame, maybe a few weeks before we come back.
How long would you request
In terms of
time for us to come back?
3 weeks or so would be fine, and then I will get a packet ready for the court and the DA for that day.
All right.
And we probably need about 15 minutes in terms of court time with the grandparents to testify.
Is veterans treatment for an option?
We can do yes, I think we should probably see about Veterans Treatment Court.
I just text to see if someone can know.
Okay.
Okay. All right, Ms. Ferguson, I need a date. Well, you know what? Let's not do a date yet. Let's confer. You confer with Veterans Treatment Court.
Okay.
Just have a seat and then we'll come back and I'll give you a date, but I'll note for the record that you're waiving PSI and TAP evaluation.
Thank you.
All right, so just have a seat and they'll be up here.
All right, let's head back to Louisiana and the board. New contestant there.
Chairman, today, my colleagues on today's panel are joining us by Zoom, Mr. Steve Prater and Ms. Jerry Ledoux. Let's see, our remote location is going to be the Tangipahoa Hope Parish Jail. Is there any staff in the room? No, there's no staff there. Okay.
He's on mute.
Oh, yeah, you're on mute. You know how to get it off mute?
Yes, ma'am, I just did it.
Oh, gotcha. Okay, good job. Okay, will you please introduce yourself with your DOC number for the record?
My name is Verdell Moore, 746-090.
Okay, Mr. Moore, today, Mr. Steve Prater is going to take the lead on your case. He's going to read your rule violations, but first, do you have a questionnaire? Do you see that? You have any paperwork in front of you?
Yes, ma'am.
Okay, this questionnaire.
Yes, ma'am.
Okay, so you recognize it and you signed it.
Yes, ma'am.
Okay. It indicates that you are not eligible for appointed counsel. The lead person, as I said, is going to be Mr. Steve Prater. He's going to review your violations and you'll be able to answer guilty or not guilty. Are you ready at this time, Mr. Prater?
Yes, ma'am, I'm ready.
Okay.
Good morning, Mr. Moore. How are you doing?
I'm all right. How you doing, sir?
Good. We need to talk about your conditions of parole that you're accused of violating. And there are really 4 conditions. The first one is number 2, and it says that you're going to submit a monthly report by the 5th of every month, and until you complete your supervision. And it says you'll report to your parole officer when you're ordered to do so. And it says that you pled not guilty to this at the preliminary hearing. Is that correct?
Yes, sir.
Okay. Well, according to what your agent said, parole agent, he said he came to the house and no one told him that your phone was broken. And then you reached out on Friday and you heard back from him at Monday and reported. Why didn't you report when you're supposed to?
Cause I submitted to text message and he didn't tell me to report to Monday. On the I got the text message right here for me. It said report to office at 2 p.m.
Well, he admits he told you to report Monday. But where were you when you were supposed to report the first time?
Working. I had just got a job working at Burger King.
And why didn't you tell your parole officer you weren't going to be there?
Cause I don't know when he comes. Like he just pops up, so I don't never know when he comes to the house or not. So I don't know when to tell him I'm not gonna be there. I had just got the job. Just got the job.
Okay. But this says you were supposed to report to the parole. I'm talking about number 2, where you were supposed to report to the parole officer. Did you miss a report when
No,
you were
sir.
supposed to go?
No, he ain't never tell me. He ain't never tell me to come. Like I submitted I sent documents in to the parole board. Well, we was texting each other and he never tell me to report. Like he reached out like that Wednesday. I told him I got my phone. I got another phone like that Thursday, and I reached back out that Friday morning, and he never reached back out to me till Monday morning, telling me to report to the office, and I went, and that's when he took me to jail on Monday I think the 27th.
Well, let's move on to number 3 then. Okay, condition 3. Is that all you need to say about number 2?
Yes, sir.
Okay. Let's see. Number 3 says, I'll live at the address on your certificate that you report. If you got to move, you'll get permission from your parole officer. Did you, when he came to see your mom, I think it's your mother,
my aunt.
She said, your aunt, she said she hadn't seen you in a week. That he had been gone for a week. And that's on his body camera footage. Where were you that week, and were you there?
Yeah, I was like, I off and on it's my aunt. She like 70 thing, but she like 74 years old, so she go to bed early. I come and I leave. I was walking to work. I go to work 6 to 2, so my mama stayed like a couple like 10 minutes away, so I walk by my mama. I might stay the night over there just to get a ride to work off and on, but I still stay at the address. She submitted the affidavit saying I still stay at the address, and I just visited my mama that stay down the road from her.
Okay, well, when you're on parole, you can't be having sleepovers. I mean, you're supposed to stay where you report that you stay.
I do stay there. I didn't know I'm supposed to stay there every night. Like I never had no problem with something like this. I've been on parole since 2019. I never knew I had supposed to stay there every night. This is the first time I'm having this brought to my attention.
Okay, how long have you been on parole?
Since 2019.
Okay, have you ever had any violations or administrative violations or anything like that? And I know the answers to these, but I want to hear it from you.
Yes, I've been in jail. I done caught charges, but all the charges I caught been dismissed and dropped. But this I think this like my 3rd or 4th time coming back to jail on parole. I go to court, go through all the process. They drop all the charges. I go back home.
Okay. All right. Well, let's anything else to say on number 3?
No, sir.
Okay. Number 4, I will not engage in any criminal activity or associate with people or do drugs or illegal drugs or things like that. Number 4, and at the preliminary hearing, you pled guilty, I believe, to two things. One has to do with violating a protective order against your girlfriend that was in Colorado.
No, my ex-girlfriend.
Ex-girlfriend, excuse me. I know you got a current girlfriend. We got a letter from her, a real nice letter. She's a nurse, I believe. And we got a nice letter from her. But did you know you had a protective order in Colorado and you weren't supposed to have any contact with this ex-girlfriend, correct?
Yes, sir.
Did you ever text her or write her on Facebook or anything like that?
Yes, I submitted. That's why my PO, Michael Smith, he brought me to jail because of that. Because I reported to him and I sent him all the text messages of her texting me and me telling her, leave me alone. I got a girlfriend, I'm not dealing with you. And they told me I wasn't supposed to respond at all. But like I told him, I'm being threatened. She's threatening my girlfriend. And they just said I wasn't supposed to respond. So that's why I was in violation to their protective order.
Okay. All right. Yes, sir. On protective order, you're not supposed to have any contact, even texting back and forth. But you say she was threatening you and you usually trying to get her off your back, correct?
Yes, yes, sir.
That's what your statement is. Okay.
And she
All
was threatening
right.
my girlfriend too. So I just like leave us alone. We ain't. That's all I was telling her. I think he submitted the messages too.
Yes. By the way, I do have those text messages, but I want you to understand, they're very difficult for me to follow. I don't understand you understand what I'm saying too. I saw you laugh. I kind of laughed too because I said I read them all, and I'm sure my board members read them all, but I couldn't tell you what they meant. Anyway, let's move on to the other part of number 4. It says that you admitted that you come back hot on the drug screen for THC. Is that correct?
Yes, sir. I ain't never I just admitted to it because I came home in February last year, and the doctor gave me a med card for marijuana, for recreational use of marijuana. And
for the recreational use of marijuana.
Yes, sir. I submitted that too. Well, I think my PO submitted it too. I don't know.
Sure. Well, okay. The conversation, and I'm not going to get too involved in medical marijuana or recreational marijuana or marijuana cards, but you admitted the use of marijuana on 10/27 of 25, and your prescription that you submitted was on 11/4 of 25.
I was going to get us a prescription every week for the use of it.
Okay, but this was the information that's in the report shows that you submitted the prescription that was dated after you had admitted the use of marijuana.
Yes, sir.
In other words, it appears that you got the card and the prescription after you had admitted using marijuana previously.
No, sir. I'll be honest, I've been smoking since I've been home, like since February. Only time a drug test ever came up was when I went to the office that Monday on October 27th, that Monday. And he told me
and I'm not saying a prescription will get someone on parole off of marijuana or anything like that, okay? I'm not saying that's the case. I'm just saying from the information, it looks like from what the parole officer said was submitted to him, it says that, let me get the exact dates right. You had a prescription in November and you admitted using marijuana in October.
Yes, sir. But it's impossible for me to get, I was already incarcerated. I got incarcerated October 27th. I sent a family member up there to the pharmacy because Louisiana don't hand out the regular med cards. They just keep it on file. and they were telling my family member I gotta get a power of attorney to get that. But I had just got them to go out there and pick up one of my prescriptions. I get it every week. I was already incarcerated, so it's really impossible for me myself to sign up and get a med card while I'm incarcerated. I just got them. The reason I got the prescription to show my PO that I wasn't lying about the situation. I admitted to smoking, so why would I lied about the med card? But he told me, I think, I don't know how you put it, like state and federal laws, something to that nature. Like it still don't, I don't know the right word, but he like it still don't justify me smoking while on parole.
Okay. Okay. And I'm not, well, I won't get into medical cards and marijuana or anything like that. I'm just going by what's in this report that I've got.
Yes, sir, I understand.
Number 10, you pled not guilty to owing money. Do you owe any money
Yes,
to the
sir.
state for?
Yes, sir. Like when I first came home, I was going to Colorado with my girlfriend working. I was getting work permits, going out there working. But I had got like 2 permits and they refused to give me more permits. I had planned on moving to Colorado, but something had came up and I ain't have no job, so I wasn't working at all. So that's why I got behind on my fees, because I was paying them. And I just got the job. My job like the end of September. And I was working, trying to pay it. I got 2 kids, another baby on the way. So I just really trying to maintain, but eventually I'm gonna get caught up with it, because he had told me in order for me to move my parole back to Colorado, I gotta catch up on all my fees and everything that I need to be catch up on so I can get that done.
Your ex-girlfriend lives in Colorado, right?
I assume so, but yes, I assume so.
And what about your current girl, your lady that you're with now?
Yeah, she stays in Colorado too.
Okay. All right. I don't have any other questions. It's difficult because you seem to have you seem to have an answer for everything. And but I don't know whether to believe some of your answers or whether to believe this report. You understand? It's kind of difficult to, it's kind of difficult to unite the two. I'm gonna turn it over to my board members, see if they have anything.
Ms. Lejeune?
Mr. Moore has a full term date of February 21st, 26. I'm prepared to vote at the appropriate time.
Okay. I just have one question. You did have a special condition in Colorado that you would participate and successfully complete a domestic violence program. Did you do that?
No, ma'am. I had registered for it, but in the process, me and my PO were trying to move my parole back to Louisiana. It's like I think the class like 26 weeks long.
That's right.
I didn't want to start it in Louisiana, and I was planning on moving back to Colorado because I had to start the class over. But I was in the process. I had registered for the class. I was in the process of moving back to Colorado, and I was gonna take the class there.
Okay, I was just wondering. So I'm prepared to vote. We'll start with Mr. Prater.
Well, my vote is to revoke because of conditions 3, 4, and 10 were violated in my estimation.
All right, Ms. Ledoux.
Mr. Moore has failed to comply with conditions of parole. My vote is to deny. I meant to revoke, pardon me, revoke.
Revoke. And I concur with my colleagues. So today, sir, you have been revoked, and this concludes our hearing at Tangipahoa Parish Jail, and the time is 9:48.
Okie dokie, friends. We're going to rotate back over to Judge Boyd, but programming note before we do. So normally the fourth hour normally we've only been doing it for a week and a half, but the fourth hour is like commentary, discussion, that sort of thing. I'm going to keep running with court into the fourth hour. And the reason is there's a lot of weird going on the interwebs right now. There's some cyber stuff going on. A whole bunch of things aren't working right. The materials that I had prepared, the stuff that I was going to cite for discussion in the fourth hour, most of it I can't access right now. But YouTube seems to be working, so we're just going to watch more court today because I'm not confident that I can put together an articulate discussion when I can't access half my materials at the moment. So anywho, Judge Boyd.
Hello.
Good morning, Your Honor.
Good morning. Sorry, I'm just marking a couple of things off. Are there any applications?
Well, on the
For
the
the-
burglary is being reduced to a misdemeanor.
Okay.
On the MTR, we're going to open on the MTR.
Okay, all right, then we'll start with the burglary. The court is calling 2025 CR 014998, State versus Vincent Munoz. Could I have parties announced for the record for the state?
David A. Garcia, attorney for Vincent Munoz, judge.
And are you Mr. Munoz?
Yes, ma'am.
Counsel, in that cause number, have you received all discovery? Did you review it with your client?
I have and we have.
Court will find that the state is in compliance with discovery. Mr. Munoz, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
Proceeding on this Western.
Any
No
objection?
objection.
Did you review court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
All right, the state is proceeding on the lesser included offense of criminal trespass as a Class B misdemeanor. The range of punishment is up to 180 days in the Bexar County Jail and up to a $2,000 fine. Did you understand?
Yes, sir.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses, and the state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do and he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is.
Mr. Munoz, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, sir.
Did you understand if you're not a U.S. citizen, by entering this plea, you may be deported, denied naturalization, and reentry?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on the lesser included offense of criminal trespass. Punishment is to be assessed at 114 days in the Bexar County Jail. There's an $800 fine and no applications. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Sure.
Counsel, there be any such motions?
No, Judge.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
We've reviewed states one and all attachments, Your Honor. We have no objections.
All right. Mr. Munoz, did you review the document entitled Waiver and Stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Judge, regarding the misdemeanor that he's pled to, we're just asking that you go along with the plea bargain and that it run concurrent with whatever ends up happening on his SVR.
All right, this is what the court will do. Court will follow your agreement. The court will find you guilty of the lesser included offense of criminal trespass. Court will sentence you to 114 days in the Bexar County Jail, give you credit for any time served. There's an $800 fine, time and money to run concurrently.
So yeah, the internet is weird right now.
With regards to sentencing.
There you go.
No, Judge.
Oh, and I'm so sorry. And this will run concurrently with all right, 2024 CR 1361.
Yes.
All right, on that cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
We're moving on to cause number 2024 CR 2024 CR 1361. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Vincent Ambrose Munoz who was placed on deferred adjudication in 2024 CR 1361 for the offense of abandoning a child criminal negligence on April 9, 2024 for a period of 4 years? Is that you?
Yes, Your Honor.
All right, state.
Violation of condition 4 and Texas, the defendant Vincent Ambrose Munoz did and there failed to report to the supervision officer as directed for the month of June 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True.
Yes, that could be under.
No objections.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility
Yes.
and up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, Your Honor.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There's not, Judge. Ultimately, it's motion and revoke his community supervision and sentence him to 2 years at the state jail facility.
All right, in defense, what are you requesting?
Judge, we went open so that my client would have an opportunity, one, to be reinstated, and if, in the alternative, to see if you could be a little bit more lenient than the state. He faces 2 years state jail. Clearly, he made a lot of mistakes. Probation's recommending revocation. The state's recommending revocation. He just pled to a burglary that was reduced down to a criminal mischief. He made a lot of bad choices. He was close to finishing one of his classes, and then the burglary arrest occurred. Doesn't excuse what happened. He made a bad mistake to go someplace with who's now the mother of his child? Mother of his child to be. She's due in 4 months?
She's due in June.
In June.
5 months.
5 months. He
What
should.
did she do when that criminal trespass occurred?
No, we found out she was pregnant when she was incarcerated.
Okay.
She got arrested with him
Ah.
at that instance. She was, our understanding was the main aggressor at the door, but the state reduced her case to a criminal mischief, and they did so with my client. He understands he made that mistake. He should have never been there. They went there to get the clothing for Kimberly's children, not his child, correct? But nonetheless, it was a bad mistake to go. He understands that. That's why he took this plea. He understands he had been making a lot of mistakes on his probation, but while he's been sitting in jail, Judge, he's tried to turn his life around. You saw the certificate of completion for the child class, the fact that he's been going to meetings. He's really been trying to change things for himself, even though he understands he made a mistake and it's a grievous mistake. He's throwing himself on the mercy of the court, hoping, one, you reinstate him. He's got a job waiting for him. He's got this baby coming in 5 months. And if not, he understands, but he's hoping you give him a more lenient sentence to 6 months in state jail or a year so that he can do his time and get back to his job and help raise his child and move on in his life.
So what has he done on probation? Has he done anything?
I did,
Want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Munoz.
All right. What have you done on probation?
I completed my first class with the driver safety course. I was right before catching this charge. I was one class away from finishing my parenting class. Then after that, I was going to start my AA. I was showing up to my meetings and everything, but I didn't end up showing to my drug testing because money was tight, but also I didn't have a reliable transportation. But my sister has an extra car that she paid off and got her new car, so she told me that hopefully willingly that she has another car for me so I can have reliable transportation to show up to my meetings, drug testing, my job and classes or anything that I need to do to be responsible for myself.
All right, any questions, state?
Or guest registration.
No problem.
Okay, Mr. Munoz, so when you were placed on probation, you provided the probation office with an address of 15800 Chaseville Boulevard. And then it was apartment 310 Fed. Do you recall that?
Yes.
Okay, whose apartment was that?
That was my ex-stepfather's.
Okay. And so one condition that you had in your probation, I guess it was amended later on, was that you were supposed to reside with your mother at 2503 Jackson Keller Road. Do you recall that?
Yes.
Okay, and so at the time that you were arrested for this charge, that you just pled to, the
Criminal trespass.
you were not residing with your mom, correct?
Yes, ma'am. It's because they ended up splitting up. My mom and my ex-stepdad.
Okay, so if I'm understanding correctly, that address at Chaseville Boulevard, so your mom and your stepdad were living together there, is that correct?
No, okay, so Boulevard, that was
Your stepdad's address.
no, the stepdad address was 2503 Jackson Keller and Chase Boulevard. I was staying with my partner's friend. She helped us roommate there, but I had ended up telling my probation officers because I had nowhere to go. That was my last option. Because I was throughout this time, I was back and forth through hotels and motels.
Okay, and so you were not residing with your mom, you were residing with Kimberly, and then the friend that was helping you all
Yes, ma'am.
out. Is that fair to say?
Yes, ma'am.
Okay, and then regarding your urinalysis, you were instructed to provide samples multiple times. If we're looking here. 9 times, you recall that?
Yes, ma'am.
Okay, and you didn't show up to provide UA 9 times.
Yeah, it was, I didn't really have too much reliable transportation, and it was just where I was staying at, my mom and people, it just didn't match their time schedules, what they were working, and I was trying my best, and every money that I did had, it was either helping out on grant or going on.
Okay, so help me understand this correctly, because you're saying that you have reliable transportation to go provide your analysis, correct? However, on the day that you were arrested for criminal trespass, you and Kimberly were in possession of a Dodge Durango, correct?
Yes.
And you all drove over to Dionisa's address, correct? So you have reliable transportation to go commit other crimes, but not to comply with your probation. Is that correct?
Yes, but I had just asked my sister if I could pick up her stuff. That was that extra car that she was that I was speaking of.
But she couldn't provide you help to comply with probation?
It was, she had just got a new car about the beginning of September. So at the time when I did ask her, she was like, she didn't really want to let me use it, but she was just like, I just needed to get his clothes.
And then you stated that you completed the aggressive driving course, is that correct?
Yes, ma'am.
And probation was provided with a copy of that.
Yes, ma'am.
Okay, but you were also ordered to do your sober support meetings and parenting class, and the parenting class is something that you completed while you were in custody after being arrested, is that correct?
Yes, ma'am.
Okay. And then the one time that you did show up to UA in July of 2025, you were positive for marijuana, correct? And so you're here asking this court to be lenient on you, is that correct? But you have not provided any evidence to this court that 1, you deserve leniency, or 2, that you ever intended to comply with probation. You would agree with me, right?
That's right.
Okay. You pass the witness.
Any further questions?
Just a few, Judge. Vincent, you sort of glommed over the fact that you didn't show up to these UA tests because of transportation, correct? Was the financial aspect also a reason you didn't show up?
Yes.
Explain that to the judge.
A lot of money that I had saved up was going towards hotels, and I didn't really have nowhere to go, so that was mainly where my money was going at, and I didn't really have a car, so I would always use Uber to get food or something like that.
And you're not trying to tell the judge that you have an excuse for everything, correct?
No, I take full accountability for my.
So you understand you did very poorly on this probation,
Yes.
but you're trying to explain why. A lot of it was financial. And so you would show up to me with your probation officer, they would tell you to show up for a urinalysis test, and you told them you didn't have the money, correct?
Yes.
Because it costs every time you show up to give a urine test.
Yes.
And so and you pled true to not showing up because you didn't, right?
Yes.
So even though you messed up on your probation, you were trying, correct?
Yes.
And you almost finished that parenting class through probation, didn't you?
Yes, I was 1 class away.
Okay, and then you got arrested because of another bad decision, right?
Yes, sir.
But while in jail, you did complete the parenting class.
Yes, sir. And then I started my AA classes as well.
Okay. If the judge grants you this opportunity to stay on probation, can you promise her, in spite of financial reasons, you'll make every meeting, you'll show up and you'll be clean?
I promise, and I do stand on that, as well as as I told her, I have reliable transportation. I talked to my grandma here a lot too. She put about 300 aside for me for my drug test. Kimberly as well. She has a few checks that she had saved up while being in here. She told me as well she could help me with my restitution fees. And when I get my job, I can end up finish paying it off and then just do my AA classes. That's the only class that I have left.
No further questions, Judge.
All right, any objection to the court asking some questions, or State, do you have any questions?
I don't have any other.
No objections, Judge.
Since 2024, when you were placed on this probation, have you ever been employed?
I was working under the table most of the time with painting. And then I ended up, when I got arrested in October, and then when I got out, it was hard for me to find a job, but then I ended up finding a job and I was working about 3, 4 months. They let me go. They were letting a lot of people go, but I was working under as a temp for Pacific Seafood. And then from there, I was working with my grandmother. She does events downtown, so I would work every weekend about selling food, setting up the booths, doing that. But while being in here, my mom has a job, and she ended up talking to her supervisors and her team lead, and they said that they have a spot waiting.
All right. And then did you tell probation that you would no longer be able to reside at the listed location?
Yes.
And that was ordered by another judge.
Yes.
When did you tell them you would not be residing at that location?
When I went to one of my probation meetings, I told her that my ex-stepdad and my mom, they ended up splitting up, he kicked us out. Cause he has a new partner. And then I ended up going with my grandma's house, and then Kimberly ended up getting pregnant about 2, 3 months while I was there.
All right, why do you say, I don't like when people use the term ended up getting pregnant. Were you not a part of that?
No, yeah, I was, not my fault.
So, I mean, everybody knows, I'm assuming, how old are you?
Me, I'm 27.
All right, people know how babies are made. So you all
We both
decide or to have a child.
She ended up being pregnant at that time, and my grandma didn't really, because of me getting locked up last year, it was a situation due with her. They didn't really get along too much, so when she had ended up finding that out, she told me I had to leave. So I was staying with her at 6818 Carversenio. I was there for about 2, 3 months. Her and her mom ended up getting into it because she had a miscarriage. Then from there, that's when we were staying at hotels and we were just trying to find somewhere to go. And then I asked my grandma if I could stay there again. My uncle ended up moving in. He was just like, I don't want nobody living here because this is gonna be my house pretty soon. And I had nowhere to really go. And then while she found her friend, we stayed at Chase Boulevard. She was letting us stay there. And then right about the ending of September, my sister told me that she ended up getting an apartment. She got another car. She was like, if you do end up not staying there, y'all can come move in with me. And then all this ended up happening.
This is what I don't understand, and maybe you can help me understand it. Why is it that people, they don't have a place to stay? They don't have a stable employment, and they decide they're going to bring a child in the world and they can't even support themselves. And everything that you've told me, and I listened to your answers to the questions, everything that you've told me, you're relying on somebody else. Kimberly has money that she's been saving up since she's been in custody. Somebody else has money, your grandmother, they've been saving up money. And if neither one of them give you that money, we're going to be right back here.
Well, I have that job waiting for me, so I'm willing to work with that. My mom told me they paid from 17, 18 an hour, and I'd be working 3 days a week. So I'd save up all my checks and just pay what I need to pay off myself, take care of my responsibilities.
Any objection to the court reviewing the court summary?
No, Judge.
Any objection? Have you read the court summary?
Yes, Your Honor.
Oh. All right, after reading the court summary, probation is basically saying you were never compliant. They said that there was a previous motion to revoke, and this was with a different judge. They say following a motion to revoke filed on October 31st, 2024 for a new offensive assault, his conditions were amended on January 9th to require weekly reporting indefinitely and residency with his mother. It says, despite these directives, the probationer refused to reside with his mother, citing conflicts, and instead stayed temporarily in a hotel before moving in with his grandmother, failing to provide proof of residence. He has remained unemployed, completed only an aggressive driving course on May 20th, 2025, and otherwise made no progress or required parenting or other classes. He has paid only $38 towards his fees, leaving a delinquency of $1,412. And see, I understand when people can't pay money, but from 2024 to only have paid $38 towards your fees, that's sort of not really trying. And they say his reporting has been inconsistent with frequent failures to appear and intermittent walk-ins, and field visits were often unsuccessful due to his absence. A manager hearing on August 22nd, 2025 documented his continued noncompliance and failure to pay fees, during which he was encouraged to obtain employment. Despite these interventions, he remains noncompliant. Yeah, I don't think probation is for you. I'm going to grant the motion. I'm going to find you guilty, revoke. This will run concurrent with 2025 CR 014998. The court will sentence you to 20 months in the state jail facility, give you credit for any time served. And I'll ask for the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign?
Yes, Your
All right, do you have a limited right to appeal? The right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. And I want you to know your attorney did do a great job, and I did listen to everything and internalize everything. But sometimes, you know, you're just not doing well on probation and there's nothing I can do. Okay.
Yes, ma'am.
All right. Good luck to you. Okay.
Thank you.
All right. On moot,
So we'll get back to her or rotate over to some other judge in a moment. But welcome to the fourth hour. Not what I normally do in the fourth hour, but again, the internet is weird. Let's give you a little perspective. On your screen right now is a real-time map of DDoS attacks. There's a lot going on in the world right now. So severely affecting financial institutions at the moment. I know 3 of the banks that we use here at the bunker are down. Pretty much anything. Microsoft is having a problem. Hulu, Facebook, TikTok are all affected. 2 of my services that use AI, that we use for parsing documents and trial dockets and stuff, are down. And then some news organizations too are fighting at the moment to maintain their internet survival. So not quite sure what's going on, but that's why I'm not doing my normal thing during the fourth hour, is I can't access the materials that I need. However, at least for the moment, YouTube is sort of kind of working. So we'll run with it. Let's go Judge DeSanto.
Excuse me, and today I appear as MIDC counsel on his behalf for arraignment pretrial. I'm sorry. And please state your name, sir.
Yeah, McNally.
All right, thank you. And today is a date scheduled for the arraignment pretrial on this matter. And counsel?
At the arraignment, Your Honor, we advise my client of the nature of the charge stands that if I today would wait for reading, stand that's what plead not guilty to be entered on his behalf.
The court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment. And as to the pretrial counsel.
Your Honor, we've resolved with the plea my client will avail himself of, and that he will plead responsible to the 2 civil infractions as charged. And if that those 2 matters are accepted by the court, then the prosecutor's motion will be dismissed the 1 count of open intoxicants in motor vehicle. He understands his rights. He's ready for the court's examination.
Sir, please raise your right hand. Do you solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
You've heard the plea that was placed on the record, correct?
Right.
As to the charge of expired plates, how do you plead? Responsible or not responsible?
Responsible.
As to the no proof of insurance, how do you plead? Responsible or not responsible?
Also responsible.
You've gone over your advice of rights with your attorney, correct?
Correct.
And you understand all of those rights.
I do.
You also understand, sir, the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
I do, Your Honor.
Knowing all that, do you want to continue with your plea?
I do.
Anybody promise you anything, threaten you, or coerce you in any way for you to enter into a plea?
Nothing.
All right, the court will accept your plea to counts A and B, dismiss count C per the plea agreement. It's $100 for count A, $175 for count B, for a total of $275. Yeah, that's to pay today, sir.
I do, yeah.
All right, stop at the window. Somebody will be with you shortly. Have a good day.
Thank you, Your Honor.
Thank you. And we are on the record in the matter of the state of Michigan versus Justina Cooley, 251686.
Ready? Step up, ma'am. Your Honor, good morning. Richard P. Serrano, P. 3828. Today I appear as MMNDC counsel on behalf and with my client for purpose of arraignment only. Please state your name, ma'am.
Did that come through?
No.
Speak way up, ma'am.
Justina Cooley.
Okay. Good morning. Today is the date scheduled for the arraignment counsel as your client walked in on the warrant, and the court will recall the warrant and ask to the arraignment counsel.
Your Honor, I advise my client of the nature of the charges against her. She understands them. Thereby will waive formal reading and ask for a plea not guilty to her behalf.
The court will waive the formal reading. You do have the right, ma'am, to have an attorney represent you. And if you are unable to afford an attorney, you may have one to be appointed to represent you. Do you understand that, ma'am?
Yes.
And in fact, you've spoken to an attorney today, correct?
Yes.
The court has also signed the petition order for appointed attorney for felony matters as well.
Yes.
You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury, and you also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights, ma'am?
Yes.
The court is entering a plea of not guilty on your behalf, scheduling this matter for probable cause conference on January 29th.
Ten fifteen.
10:15 a.m. and as to bond.
Your Honor, my client is a single. She is 33 years old. She presently lives with her boyfriend, not on probation or parole, no criminal matters pending. And Your Honor, she was employed, obviously, no longer employed. You're not working anywhere else, are you, ma'am? Is that no?
No.
Okay. And Your Honor, she apparently never failed to appear in court before, and we would ask the court to consider a personal bond. She wasn't even arrested. We'd ask the court to consider a personal bond or bond she could reasonably expect to post, but I think it's very, very tight for her these days.
Okay. So, ma'am, how long have you resided at the home in Allen Park?
About a year.
Is that with your boyfriend? That's the house there?
That's the apartment?
Yes.
How'd you become aware of the warrant, ma'am?
I've actually been checking on my court case just to be safe. And, I caught it about 2 days after the warrant got issued and that's why I came today.
Well, you were supposed to have been here January 8th and you failed to appear.
Correct, ma'am?
Yes, it is.
Why didn't you show up?
I'm actually currently unhoused and, I've been
What does unhoused mean?
homeless. I'm homeless. I don't actually have I'm kind of residing on my mom's couch currently, and I didn't actually receive a notice because they didn't, no one, I guess, had a permanent address listed for me.
Well, the address that we had in our system is the one in Taylor.
That's a very old address, yes.
Well, it's also the one that's still on file with the Secretary of State, ma'am.
My license or my state ID is due to be reviewed this year. Actually, I just haven't updated the address. I have receipts of where I've been living and stuff. My boyfriend's been paying and everything.
Okay, my point is, ma'am, is that the court can't chase people around everywhere they move.
I
So
know.
it's your responsibility to change your address with the agencies that you change your address with, specifically the Secretary of State. And how are you supporting yourself, ma'am?
I currently don't have a job. My boyfriend's been helping me and my mom's been helping me
How long have you not had a job, ma'am?
for about a year. I'm working on getting disability for my mental health.
And where are you at in that process?
I just got paperwork sent over to me and signed stuff. I have to go into the Social Security office and actually sign more paperwork, but they told me that I didn't have to do that until next month, beginning of February.
Well, ma'am, whose apartment is this? If you're unhoused, whose apartment is it?
My mom's.
Do you sleep at your mom's?
Yeah.
Based upon the nature of the charges and Ms. Cooley's failure to appear at the arraignment earlier this month, the court's going to order a $30,000 personal bond. You have the following bond conditions, ma'am. You are not to have any contact with any Circle K employees. That's phone contact, text message, email, social media, third party, anything of the like. You are not to enter the premises at the Circle K in Riverview. You are to have a GPS tether through the Wayne County Jail. So you need to go over to probation and they will give you information to make sure that you obtain that tether. And we'll see you back next week.
Thank you.
Have a good day.
Yes, Heather, you're on.
Yes.
Thank you very much, Your Honor.
Thank you. We are on the record in the matter of the City of Wyandotte versus Dante Mendoza, 251.
Actually, no, we're not. Let's go back to the board in Louisiana.
For the record, please.
Melissa Devaney.
Okay, all right. Miss Gambetta, and I'm correct there?
Yes, ma'am.
Okay, Miss Gambetta, I'm gonna read some information for the record, and at the end, you'll let me know if everything is correct, okay?
Yes, ma'am.
All right. Chantel Gambetta is your name. Your DOC number is 786-864. You're a first-class offender. The offense is Livingston Parish 44069, attempted trafficking of children for sexual purposes and promoting prostitution. Your sentencing date was March 11, 2024. Your sentence was 5 years, DOC hard labor, suspended all but 3 years, and then 3 years supervised probation. Your parole date is March the 20th, 2026. Your good time date, you're not eligible, and your full-time date is December the 20th, 2026. Is that correct?
Yes, ma'am.
Okay. All right. In your own words, will you tell us why you're here today?
To be granted parole.
Okay, want to tell us, in your own reason, well, you said to be granted parole, but why are you incarcerated? What brought you to this point?
I was hanging with the wrong crowd and led me to do wrong things, and I made a mistake.
That's very vague. Anybody could say that. What happened?
They had we had a hotel room, and they had a person prostituting out of it, and the hotel room was in my name.
So you're saying you didn't have anything to do with it?
No, ma'am. I take full accountability for my actions.
For your actions that you rented a hotel room?
Yes, ma'am.
Staff, do you have any comments?
Chantel has been in all kinds of courses, even though she doesn't get good time credit while she's been here. AA, Bible study, living in balance, celebrate recovery, life's healing choices. She's worked in the kitchen for a long time, and then she also works at 911 and cleaning and commissary for us. She has no disciplinary record.
Mm-hmm.
As far as she does anything we ask her to do, she's no problem at all.
Mm-hmm. Well, that's speaks very highly of you that you wanted to be a part of those classes just for your own self-improvement. I'm glad you let us know about that. Okay, at this point, we're going to listen to supporters for you, which would be Leah Joseph, your sister.
Good morning.
Yes, ma'am. Good morning to you also.
How are you?
I'm fine.
So she's my sister, and she has my full support if she's able to come home. I think she learned from her mistakes. She talks about all the good things she's done while she's there. She has a job lined up for her. She's a very good person, just was under the bad influence of just being around the wrong crowd. She has a job lined up. She would love to be home around her kids. I think she would be going to church, be involved in the community. And she has the support of me of helping her get a job or a TWIC card to get into a job, help with her children, find her a place to live.
She'll be staying with you?
I don't believe at the moment she had already made arrangements to stay with our mom, but if she was granted to stay with us, if she was allowed to stay with us, absolutely she could stay with us.
Family.
Yes, ma'am.
Okay. All right. Thank you very much.
Thank you. Yes, ma'am.
Okay. At this time, we do have opposition, and we're going to start with opposition would be, I'm just going to read the names. Tamika White with the JDC, the DA's office, 21st, and then Michelle Sparks. She is with Tamika, and Kathleen Costa. She is there also with the JDC. And speaking today will be Alexis Taylor. She is the ADA at the 21st JDC. Ms. Taylor.
Good morning.
Morning.
We at the DA's office are opposed to her release. She was responsible for escorting a 15-year-old child to a hotel to perform sexual acts for money. It is my appreciation that the acts were scheduled through a website by the defendant's boyfriend, and the defendant would escort this victim to the location to perform the acts. And just going through the report, the victim stated that she tried to have the defendant, Chantel, not bring her to any more hotels, and that she did not want to keep doing this. However, the victim stated that Chantel made her go to the comfort suites and stated to her that she did not have choices anymore and that she had to make money for her and her boyfriend. The victim stated that once Chantel dropped her off at the hotels, she would leave her there and would not return until after all the clients were seen. So based on that set of facts, the victim's young age, the state is opposed to the defendant's early release.
Yes, ma'am. Thank you very much. Chantel, your case has been assigned to me, and I'm going to conduct the interview, and I will later cast the first vote. Well, you heard what the DA just said. What do you have to say about that?
That I'm deeply regret that the actions I have caused, and I apologize for any of my decisions that I had made, and that I'm sorry to the victim and their family, my own family, and even the community.
Well, you know, when I asked you earlier to say in your own words what happened, you didn't say any of that. Just that you made a mistake and you were sorry. Is there a reason why right now, the victim said that she asked you not to make her do it any longer? Can you expand on that? What was going on that caused you to make her do it anyway?
It was a bad spot, and it was not my boyfriend defendant. It was nervous. A man. He basically made me make her do it, and I went along with it. And I know I was wrong for the crime that I have committed. And if I could take it back, I would tell her that I'm very sorry, and I apologize.
Well, the gravity of human trafficking is these are all strangers.
Correct. It's a serious crime.
It is a serious crime, and at any time, the child could have been beat up.
Correct.
So, I mean, human trafficking leads to a litany of other things. It's bad enough when, you know, when you have rape of a child, a lot of times it's a family member, somebody they know well, and that's heartbreaking, and that's frightening also, but this is terrifying what this child went through. So did the child stay with you, or did she go back home, or how was that?
She was considered a runaway, and her mom had let her stay with me. And she went back home to her parents. I think she went to a juvenile helping center to get help. I'm not really sure. I had a stay away order, so I didn't go in contact with her in here or anything.
Well, how was it found out that y'all were doing this?
They had got caught up in the hotel. I think other people from the other rooms have reported it.
Mm.
And when I had got pulled over, they had let me know that I had a warrant. And I had served 4 months in 2022. And I had got out. They let me out on a OR. And then I just went to court every month, or whenever they had court, I went for like 2 years. And then I had to turn myself in after my plea. And I've been incarcerated since.
The victim feels like your boyfriend played a significant part in this, as far as she feels like that you didn't know how to get out of it. Was that true, how she felt?
Yes, ma'am. I was also pregnant at the time, so.
Did see that. It was with his child?
Yes, ma'am.
Okay. All right. You should know that you had support letters from family, 7 of them, from work, you had one. So and then there was another one. So you had a total of 14 support letters. But total opposition from law enforcement. The sentencing judge had no comment to your release. I will turn it over to Ms. Ledoux. Did you have any questions?
No, I just would make note that for release, an inmate has to have pre-release and substance abuse completed. And we don't have the substance abuse shown that it's been completed. So she would not be eligible based on those things, although she has a full term date in December. So I don't have any other questions or comments.
Mr. Prater?
Yes, what's the status of Joshua Johnson's charges? Do you know that?
Are you asking me, sir?
Yeah, what was?
From what I know, he's never went to court for it. I'm not really sure. He's fighting another charge in another parish.
Okay, are you gonna testify against him if it comes up, or y'all still have a relationship?
No, sir, I don't have no contact with him. But
Have you had any contact with him since you've been in jail?
No, sir.
Okay. That's all the questions I have.
Okay, you can close with telling us anything else you would like us to know. Consider, Ms. Combetta.
During my time in incarceration, I have made personal, emotional, and spiritual changes in my life. While I can't change the past, I am committed that I can show and prove that I can be someone better. Even though I'm not eligible for classes, I still took them, and completing the programs, it showed me that I'm capable of being a better person.
I do have one question for staff in the room, and Ms. Ledoux brought it up. The eligibility for parole is that we have the pre-release programming and substance abuse treatment. Is that offered to her? Was she just not? I see where she took so many other classes.
No, ma'am, we don't have that here. I know in the past when y'all granted parole that they were transferred to the women's prison to complete the reentry and the substance abuse over there. I think in St. Gabriel's.
Mm-hmm.
We had one maybe in December that went for just that.
Okay, and you're going to be getting out in December of this year, so that would, Ms. Ledoux, that would fall in line with the time frame if we had her transferred. It's like 100 hours, right?
Yes, and yeah, I can't really speak to that. I'm sorry.
Okay, I understand. What? Okay, all right. So I'm ready to vote at this time. And
could I ask?
Yes, please. Yes.
I got just a couple of questions that really, because it's a tough case. Did you know this? Did you know her age? That she was underage?
No, sir. She had said that she was 18, and I found out her age when we were at a hotel and her mother had seen her. And that's when I found out she was a runaway, and her mother told me her real age because they wanted to press charges. But her mother said if I meet her and talk with her, she would have a conversation. And that's when she told me her age and everything.
Did you ever have her used after that?
No, sir.
Okay. How old were you at the time?
I was 29 or 28, about 28, turning 29.
Okay, so you were grown and you couldn't tell that she was only 15, or how old was she when she started?
She was 15 and she was going on 16. Her mother told me she was 15.
Okay. Were you doing drugs at the time?
No, sir, I never did drugs.
Were you drinking a lot?
No, sir, I don't drink.
So what excuse do you give for pimping this girl?
More so, it was it was me, but more so of the man making me. I was just in a rough situation with my kids' father.
What I have to decide, okay, I had to decide in the parole board, each one of us has to decide different things. I'm trying to decide if you get out and this guy calls you and wants to go out on a date, even though the staff and everybody you work for now thinks you have really, they probably would have said that prior to you. If you weren't doing drugs and weren't doing alcohol and they got to know you, you were probably a nice person back before you met this guy. Is that correct?
Correct. I was different from when I met him, but I have no contact and I'm not planning on having no contact with him.
Well, you're not planning on it, but you might. In other words, are you so easily led that if this guy calls you, you'd be willing to do what needed to be done?
No, sir, I wouldn't.
How much more time you got?
To December 20th of 26.
Okay, so you're looking at 11 more months.
Yes, sir.
10 more months, really. Okay. That's all I got.
Yeah, and I would like to expand on what Mr. Prater said. In our synopsis of the arrest report, it has that that you were responsible for picking up different females, and that was one of the reasons why the phone call was made, because they saw all the blood trafficking going on in the room. So we've got the one child, but as far as I can tell, you were very involved in picking up different females and causing them to do this. Is that correct? It wasn't just the one child.
No, ma'am. There was another day. He had a girlfriend that she was 24. Her and then the 15-year-old. There was no one else.
Who you knew to be a runaway and who we know she asked you not to make her do it anymore. Am I correct?
Yes, ma'am.
What? And the reason you say you did it is because you were in a rough spot. Am I correct about that?
Yes, ma'am.
Got 11 months left. Okay,
Let me ask.
Yeah, okay, go ahead.
I keep getting these questions that come up. So Joshua had, that's his name, correct? Your
Yes,
fellow
sir.
you were going with. And he had another girlfriend?
Yes, we were in the part of separating. When I had got pregnant, I was 3 months with my little girl, and we were trying to separate. And he didn't want me to leave him. And I found out that he had a girl, which was his girl. Come to find out to be his girlfriend. So I was putting on.
Did you stay with him after that?
No, sir. I had got 2 jobs and was going my own way.
But you were with him the night you were arrested, correct?
Yes.
But you said you had already left him by then.
Yes.
So if
We
you had
had-
left him, if you had left him, if you had left him mentally, but you were still with him physically, what made you do what he told you to do?
More so nervous, scared.
How much money were you making?
I really wasn't making anything. It all went to him.
It all went to him, and you
Yes.
kept doing it, even though you decided to break up, even though you knew he had another girlfriend, and you continued to do it free. Is that what I'm hearing?
Yes, sir.
That doesn't make sense to me. That he had some kind of magnetic hold on you, and I'm fearful he will still have it if you're that weak. Okay, that's all the questions I got. I'm sorry.
Yeah. Are we ready to vote, panel? Mr.
I'm ready.
Okay, and Ms. Ledoux? Okay,
Ready.
this time, you have followed through with some other classes. And, you know, I'm going to try to see if you can be transferred for your pre-release programming and your substance abuse treatment so you can get that finished before December. But I cannot agree to granting your parole request. The crime was just too serious. It was a runaway. She really didn't have anybody to turn to. And you said terrible choices, but you clearly made them of your own volition. You chose to make those choices. I mean, he didn't hold a gun to your head or anything like that, based upon what you said. And you said that he hadn't even been charged with anything yet that you're aware of anyway. So my vote today is not to grant your parole. I'm going to request that they transfer you to a location where you can get your pre-release programming and your substance abuse treatment. You only got 3 years for a horrific crime. So I guess that was through a plea bargain. Is that correct?
Yes, ma'am.
Yeah, so your plea bargain, 3 years. So I feel like you should serve your full term. And then I'm going to request, if at all possible, that you be transferred to a location where you can get your pre-release programming and your substance abuse treatment. Mr. Prater, what is your vote?
Deny terrible crime. I'm really fearful that she's going to continue if she doesn't get some real help and some real support. This was a terrible crime of a grown woman allowing a juvenile to go into prostitution regardless of her status. And I appreciate the assistant DA's comments. And for that reason, my vote is to deny.
Okay.
My vote is my vote is to deny parole. I wish you well.
Thank you.
Hey, ma'am. So today your vote has been denied. I mean, your parole has been denied.
Actually, I think they can go ahead and deny her vote as well while they're at it. Maybe deny her a few other things as well. So due to circumstances beyond our control, we did not do our traditional fourth hour today, but I will say a few words on this particular case before I let you all go. I think, as she puts it, that she should just stay incarcerated for as long as humanly possible. Not only for the act that she did, but quite honestly for her handling of this entire hearing. I've kind of been of the opinion that every now and then we see somebody that handles this so poorly that they ought to have time tacked on for it. And this is one of them for me. It was all talking points and buzzwords. God, classes, changed person, blah, 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 but no real accountability. And I wrote this down when she said it. Quote, if I could take it back, I'd tell her I'm sorry. That doesn't even make sense. Because if you took it back, you would not even need to tell her that you were sorry. Because if you took it back, it never would have happened. But of course, you can't take it back. So perhaps what she should have said was, I regret incredibly what happened. Very poor choices. I don't know what I was thinking. I wish I had the ability to tell her I was sorry. But not that. She just had a whole bunch of talking points in her head, probably fed to her by her jailhouse lawyer staff, and just a total fail. The other thing that caught me on this one that I can't stand is the whole "the man made me do it" thing. No. Nobody makes you do anything. You make the choice to do it. Because you always have the choice not to comply. Even if the man was roughing you up, even if the man was going to beat the ever-living crap out of you, you still have a choice in that moment to not comply. I'm not saying it's going to be pretty. I'm not saying that what the guy is doing is right. Of course not. It's incredibly wrong. But you still have agency over the choices you make. I don't care who you are. You do. And it drives me nuts when somebody goes and tries to place blame upon somebody else for their own actions. Own it. You did it. You know, whatever the circumstances were that got you there, that is immaterial, in my opinion, if you took the decision to take that action. That's on you. And you know what? We all get in places in life where, unfortunately, the moral decision, the right decision, isn't necessarily the easy one. It isn't the pain-free one, but it's life, and you have to deal with it. You have to accept it. All she did was pass whatever misery, assuming that the guy really did make her do it. So we're making an assumption there. But assuming that was the case, the only thing she did was take the pain that she would have suffered and passed it on to a child. That's on her. And I have no sympathy whatsoever. Like I said, she ought to have time tacked on after today rather than simply a parole denied, but that's just my opinion. Okay, friends, we're going to call it a day. We'll be back tomorrow, 9 a.m. Eastern, 6 a.m. Pacific, half an hour early for channel members, and I promise I will schedule it right this time. I put it up as an unlisted post and forgot to change it to a members only, so I apologize that we missed the pre-show this morning, but we'll have that back tomorrow. We'll also have sidebar, and assuming Michael is recovering well enough from his dental work earlier today, I think later today he and I are going to film the pilot for In the Blind, and probably get that posted tomorrow if we can get that done today. So those are the plans. Go have yourself a great day today. I look forward to seeing you tomorrow. Thanks to all of you for your support. It means a lot to me. So take care. God bless.